the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel. I'm joined by my dear friend, colleague, Judge King, who's on the phone, and Judge Diaz, who you can see on the screen. I'm going to ask all counsel who are not arguing in the first case to please, I guess not mute, but dim your video this time. All right, I think that everybody's done that. Mr. Walters, you may proceed.
Good morning, Your Honor. Again, may it please the court, Neil Walters for the appellant in this case, Wayne Burnley. This case presents two sentencing issues. The first is the propriety of a three-level role in the offense enhancement under 3B1.1b of the sentencing guidelines. And the second issue was a two-level enhancement for reckless flight from arrest under 3C1.2. I'm going to take the issues up in that order. 3B1.1b authorizes a three-level enhancement if the defendant was a manager or a supervisor. The guideline itself doesn't say much beyond that. The court has said that we use the standard dictionary definition of that. However, in comment 4 in the notes, the guideline sets forth 7 factors that a district court is supposed to consider when it makes this determination. And this court has indicated on a number of occasions the importance of the district court actually considering and articulating its consideration of those factors. First error we submit, Your Honors, in this case is that the district court didn't do that. If you look at the district court's decision, the sentencing hearing, trial counsel did note an objection, raise an objection to the conclusion that that three-level enhancement was necessary. And simply what the court said was, I think the evidence here in the pre-sentence report is accurate, and by preponderance of the evidence, at least, he was a manager at different times of Constance Lehman, Kathleen Varner. He instructed Varner to collect money for him and instructed his sister, Rebecca Burnley, who is not indicted but is part of the conspiracy, to move the money on his behalf. That is the sum total of the district court's analysis of that issue. There's no discussion of, in particular, of any of the 7 factors. Arguably, those statements went to one of the factors, which was, well, actually, the 7th factor is the degree of control and authority. The district court's decision seemed to say that there was some control or authority there. So that's our
Mr.
first.
Walters, Mr. Walters, excuse me, Judge Diaz here. Is it your position that that a court has to find evidence sufficient to satisfy all of the factors, or say, for example, in this case, the court had expressly recognized these factors and said, well, it may be that some of these don't apply, but I'm satisfied that because he was an active manager and or directed the 2 individuals that you identified, that that's enough in my book. So what's your take on that?
Certainly, Your Honor. First off, I don't think the district court ever said that in this case. But with that said, my understanding of the cases, and it's not so much that the court has ever said you have to consider all of them. The court seemed to mention some of them. So I think the answer to the court's question is I'm unaware of any case law or in the guidelines requirement that all of the factors be considered and all of them be weighed and the court articulate its weighing of those. I do think that is the answer, that the court is supposed to consider all of them, and if some are not factors are not relevant in a particular case, it should say so. It's that to get meaningful appellate review, the court has to indicate, I am considering these factors and here are the facts that I am applying to them.
So in the Chambers case that I think you were relying on, there was, I think the court was concerned that there was simply no indication that the court made any findings with respect to this issue of whether or not someone was a manager, leader, or a supervisor. But that's not this case. I mean, the district court judge seemed to focus in on what it seemed to me anyway, whether pertinent was the relevant evidence on whether or not there was enough to warrant the enhancement. So why isn't this case different than Chambers?
Sure. Well, Chambers, what the court said was that the district court found simply that Chambers was at least a supervisor at some level. That was the some extent of what the district court said in Chambers. Here, I would submit, Your Honor, it's not that much different, other than he says, okay, he instructed Varner to collect money for him and instructed his sister, Rebecca Burnley, to move money for him. That's the only additional things the court says here besides what was said in Chambers. Our issue there, Your Honor, is when you look at the testimony that was before the court, that was not, in fact, what people testified to. Varner never testified that she was instructed by Burnley to collect money for him, and her testimony is at pages 101 through 123 of the joint appendix. And if you read through that, you're never going to find her saying that I was instructed by Burnley to collect money for him. She says that Christopher Mays was supposed to collect money, but he never did that. So this gets into, obviously, the court reviews, to the extent that the district court made a factual finding that Burnley instructed Varner to collect money for him. Our position there would be, Honor, that's just simply clearly erroneous. When you look at Varner's testimony, she never said that. Nobody ever said that Burnley instructed her to collect money for him. There was various people said, oh yeah, people were supposed to give money to Burnley for drugs that were sold while he was in jail. But the whole issue is nobody ever did it. Nobody ever followed that instruction. And this really gets to, I think, the core of, this was an issue that the court in Wilson, which was after our briefing was done, it was.
Mr. Walters, I think you indicated, excuse me, you indicated, and I appreciated the analogy that your client was the, quote, Rodney Dangerfield of this conspiracy. And but wasn't there evidence in the record that immediately after his arrest, he did direct several of his co-actors to go try and retrieve the evidence of the drugs that were allegedly thrown out of the car as he fled from the police?
Your Honor, again, this is where a careful read of what the testimony actually was is important. And again, I was gonna make a comment about, and I'm just reflecting on myself that I was old enough to know who Rodney Danger was, and I appreciate Your Honor humoring me on that. I also have an age-related problem that the names here are sort of running together. But if you look at the testimony,
I think Mr. Walters, you and I are both old enough. When I imagine if I had mentioned that to my law clerks, they would have looked at me with a vacant stares, because I don't know that they would have had a clue who Rodney Dangerfield was. But
the worst
that's
part
neither here nor there.
Certainly.
So go ahead.
Certainly. So what the testimony was that he called me and told me he had thrown this stuff out there, and she said there were some pills for me there, and this gets to Judge Gregory's point in the Wilson decision, which is you really have to look more deeply at these things. That sometimes this is just what people who are in the Wilson case involved a gang, but people in a group will ask each other to do things for them. The analogy I had in my brief is two employees are carrying, the desk upstairs, and one of them tells the other one, put it down and turn left here. That doesn't mean the other person is under their control. They're just doing what people would do to help each other out. So I think if Your Honor looks at that testimony, nobody says, he told me to go out and find these drugs, and I felt compelled to do that because he's my boss. It's, hey, I wanted some pills, and we're all in this drug business, and he told me where he'd thrown it. And I think an equally plausible read, and certainly the district court doesn't address this at all, is that, yeah, she wanted to get her pills, and there were some drugs out there, she went to get them. Of course, it turns out they're not there when she goes. So again, the issue isn't so much, did Mr. X tell somebody to do something and then that person did it? It's, did the person do it because they felt that they were subject to the hegemony or control of the person who gave that direction? And I think looked at in this context, a lot of what the people do here is what people who are drug dealers and drug users and drug sellers would do. Okay, the guy I was getting stuff from is now in trouble, or he's in prison. I'm going to start reaching out and finding out who my supplier can be, those types of things. Fortunately for Your Honors, I'm not allowed to submit a 200-page brief. I think the best brief in this case is the entirety of the testimony. If Your Honors work through that testimony, I don't think you'll ever see any true indication that anybody felt compelled to do what Mr. Burnley suggested they do. And it's another, in the Kimmel case, one we cited is, again, what the court says, look, when people make suggestions, even in a context, business context, Kimmel was the one involving the used car Ponzi scheme. you know, people may well take those suggestions. They may make good business sense, but that's a quite different thing from saying, I felt compelled to do this because this person exercised dominion and control over me. The First Circuit, you know, has a humorous analogy to the Oscar Mayer hot dog salesman and those types of things. But to circle back to the first point, these are all important things, and there's simply no analysis from the district court with respect to that. Certainly, what the court has said in Chambers, and I believe in the Kimmel case was another one where it was sent back. You know, it may well be that the evidence would support that conclusion, but the district court has not done the required analysis on the record for this court to say, yes, that was a non-erroneous decision by the district court. So,
well, it has to be clearly erroneous, right? It's just not that we think Judge Crowe, I think, might be wrong. Just the judge has to be clearly wrong.
Well, certainly on any factual issue is reviewed for clear error. And again, I said, we isolated a number of areas in the testimony in our briefs, but again, I don't mean to keep inviting the court to spend a couple of enjoyable hours reading that testimony. But again, Your Honor, the findings that were articulated, we do submit are clearly erroneous. To say that Varner was instructed to collect money for him when Varner never instructed and nobody else ever testified that she was instructed to collect money for him, and the testimony on the record indicates that she didn't actually collect any money for him. The other reference was to Becky Burnley being told to move money, but again, Becky Burnley didn't testify at trial, and Christopher Mays, who did testify, and one of the main witnesses, said it was Mario that told him to give the money to Becky. But anyway, he never testifies that he did it, and it's clear that the next discussion with Mario, they decided to cut Burnley entirely out of the operation. So I agree that it's reviewed for clear error. I think the court's decisions in Chambers and Lamas, which was another one that dealt with what happens when the district court fails to make these findings, simply said, look, the evidence may or may not support this. District court, it's coming back to you, and you have to perform that analysis. I think the government invites the court to say, well, let's look at all the other evidence that's out there. But of course, that was explicitly rejected in Lamas. The court said, no, that's not how it works. That's not what we do in 3B1B cases. So that I think, you know, on the record we have, I've submitted those findings are clearly erroneous, simply because I think what happened, Your Honor, was that is what the probation officer said in the pre-sentence report. The district court quotes that almost verbatim. But again, when you look at the testimony and then you look at the underlying description of the events in the case in the PSR, that those statements aren't there either. So I do submit, Your Honor, that those are clearly erroneous. It is the test for factual determinations are made. But I would submit that Lamas and Chambers indicate that if that analysis has not been done, the court may never get to the clearly erroneous test. It has to send it back and have the district court do that analysis in the first instance. I see I've just got a couple minutes left. I don't want to, if I haven't answered Your Honor's questions, I don't want to move on. I just wanted to briefly touch on the flight from arrest 2-level enhancement. And again, this is one where the courts have not adopted a bright line test that every time you have somebody fleeing arrest in a car, you automatically get that enhancement. This court's decisions, again, we cited a number of them in our briefs, have indicated.
Can I ask you about that, Mr. Walters? So there may not be a bright line test, but it would seem to me to be almost common sense that if someone flees from the police in a car and in the process runs over one of the officer's foot, that would seem to satisfy the requirement that it was done with at least a reasonable probability that someone could be severely hurt, injured, or otherwise, so anyway, so why isn't that just common sense that on these facts, those facts, plus the fact that he led them on a high-speed chase for an extended period of time, why isn't that enough to satisfy the enhancement?
Certainly, Your Honor, a couple quick answers. Then I see I'm down a minute and a half. If I'd like to at least finish the answer, I suspect I'm going to run over. First off, as we discussed in our brief, the running over the foot. Well, let me back up. The district court, in its factual findings on
this is Judge King.
Certainly.
This argument's not nearly as good as the one you had for the first factor, or first enhancement. You admit that, don't you?
Well, it's never what I like to hear, Your Honor, but I was telling my wife last night, I'm always really impressed with the strength of my argument right before I argue it. You know, I do think, Your Honor, that certainly the 3B1.1B1 is stronger. I do think there's less to the running over the foot than appears. The officer told him he was fine.
Well, he ran over the foot. If he a few inches, he could have killed the officer. Just on that point, and then they end up in an accident, wreck too, right?
Well, they did, I think, one of these controlled impact things where the officer hit the back of the car to cause the other car to go off the road. You know, I'd admit,
Okay.
Judge King, Your Honor, that running over the officer's foot is not the most helpful fact in the scenario I have here. I think the strongest issue there was the judge didn't articulate that that was an issue he was considering, and I think Lamas and Chambers have been clear those were at least 3B1B cases rather than 2C1, wherever this is.
It just jumps off the page here, though, as Judge Diaz indicated.
Well, it certainly does. There's no way to sugarcoat that one other than, you know, is that rise to the level of having toddlers in the car and shooting your automatic pistol out the window at them? You know, you're right. There's no bright line rule. You have to draw the line somewhere. I would submit, Your Honor, that simply looking at the facts with respect to the district court didn't rely on that, and it didn't even mention that in its decision. And within a moment, Officer Sanchez, Deputy Sanchez, was able to have Mr. Burnley back in his sight. So nobody spent a lot of time trying to figure out what happened. But I'm like I said, I'm not going to sugarcoat it, Your Honors. That's not the most helpful fact out there. I see I'm well past my time. It looks like Judge Gregory might have a question for me. Maybe he's just going to tell me to sit down.
No. I just want to say that, cut to the chase, Mr. Walters. What element of that enhancement is not present here?
What element of the reckless flight from?
Yeah, what element is not present?
Well, I think, Your Honor, the recklessness element. I mean, if you're going to say every time you flee from the police that's reckless, then you've got, you know, just the default every time there's fleeing from the police in a car. You know, I guess you could have a case where the person peels out at a calm 25 miles an hour, you know, stops at the stoplights, but clearly that's not ever going to be a situation either. So I think the recklessness is absent in the sense that this was in the middle of the night. It was 2:55 in the morning on rural roads. There's simply no evidence in the record whatsoever of any other thing other than he fled. There's Deputy Sanchez never gives a speed, as one of the PSR says, high speed. So really, if you're gonna,
well, we do know a pedestrian was nearby.
The one whose foot was run over.
Yeah.
Well, no, right. I say so that's the only factor there. If you say yes,
do you need anything else for recklessness?
Well, I know what my answer has to be, Your Honor, and I would submit that there's recklessness, and then there's, you know, what the facts in this case show. And I understand Judge Diaz's question. You know, it could have, or Judge King's question, it could have been a lot worse.
Right. Well, the facts in your case is pretty bad because, as Judge King said, a few inches, you may have had an officer that was severely injured and perhaps killed. So it's hard to take your scenario out of a situation where it's not close to recklessness. Even if, I mean, you would be a case where nothing happened. It was 2 o'clock in the morning. Nobody was on the road. You stopped in 500 yards, and where's the recklessness? Those aren't your facts here.
No, they're not. And after 100 some odd times in front of Your Honors, I've sort of learned to not belabor losing points. You know, but that's the sum of our argument, Your Honor, that in comparison to other cases, there's one factor here, yes. Whether that one factor gets it over the 50-yard line, I'm obviously going to defer to the panel, and I sense where that's blowing. I do see I'm 3 minutes over. If the panel has any other questions on the 3B1.1, I'm more than happy to address them. Otherwise,
Mr. Walters, I do have an additional question. So
certainly.
If we don't agree with you on the second enhancement, but believe that there might be some merit to the first, does that change the guideline sentence in this case, or is it sentence still within the reduced guideline? I
do not have the table in front of me. If both of them were granted, it would drop to a 36. He was at a 41. 5 would drop it to 36. As I recall, 36 may be the point at which the lower end of the range starts to go down. I'm certainly happy to look at that during opposing
Okay.
counsel's time to argue, but
Yeah, I'm just wondering if it, you know, if the second one is against you, but the first one is with you, but the guideline range, the sentence is within the modified guideline range, whether there's at least a contention that it doesn't matter.
Well, Your Honor, and I don't mean to make the government's argument for it. I mean, the sentence, but it ties into what my response would be. The district court sentenced under the range anyway. It gave a 300-month sentence at the original case, even though that was below the bottom end. And our position would be, given that the district court has indicated its indication to give a sentence below what the guidelines would otherwise call for, that if the offense level is going to be even lower, that there's a plausible argument that he could have sentenced even further down if the offense level was not so high, Your Honor.
Okay.
Thank you.
All right. Thank you, Mr. Walters. Ms. Rottenborn.
Yes, good morning, Your Honors. Laura Rottenborn on behalf of the government. The district court's factual determination that the managerial role enhancement should apply here was not clearly erroneous. As this court held in Holmes, once a court has determined that the defendant exercised some control over at least one participant, it need look no further to whether the defendant exercised control over anyone else. Here, our district court found that the defendant exercised control over at least 3 people. And if it suits the court, I thought I would identify the portions of the record where the managerial role of Mr. Burnley is most clear. The district court found that defendant Burnley managed co-conspirator Varner and did so in multiple ways. JA 111, which is Varner's testimony, talks about the specific role she played under his managerial influence in helping distribute the kilos of meth that he was purchasing from his source of supply, Mario. The testimony on JA 111 explains that Burnley would buy the meth from Mario, bring it back, divide it up at his home, and hide the meth in lesser quantities in PVC pipes, which he would then hide in the forest or around his yard. And he would then instruct Varner at various times to go collect the meth when he was ready to sell it. And Varner would do so. She would collect the meth from these PVC pipes, and then she testified that she would drive around with Burnley when he would sell it. It is also clear that this fetching that Varner would do of the drugs was again repeated after Burnley was arrested, when he instructed her from jail to go collect the meth that he had thrown out the window during the high-speed chase when he was eluding police. These facts alone are sufficient to warrant the managerial role enhancement, especially under a clearly erroneous standard of review. Opposing counsel stated that nobody had testified.
Ms. Rottenborn, can I ask a question? So that series of facts that you just laid out, I have no doubt that they appear in the record, but the question is whether or not the district court found those specific facts. Did the court find that?
The court found that Burnley was a manager at different times of Varner, and that he had instructed Varner to collect money for him. Those are the specific sentences that the district court articulated when imposing the guideline enhancement. And it's the government's position that that is a sufficient factual finding to support the enhancement here, and that further specificity is not required. It is, of course, clear that a trial court must state with particularity the individual reasons it's imposing a chosen sentence, but the case law makes more clear that the degree of specificity required when making a finding of fact upon which that sentence is predicated is substantially less. And as Judge Keenan explained in the 2013 Stephan decision, which postdates Chambers, this court, when reviewing a factual finding, can look both at what the reasons are articulated by the district court judge, or may affirm based on any evidence in the record. So here it's the government's position that yes, the district court judge made a sufficient factual finding when he said that Burnley was the manager of Varner and instructed Varner to collect money for him. But this court, of course, may look beyond those factual findings to the evidence in the record, the undisputed evidence in the record, and conclude that the enhancement was properly applied. I would also note here
Ms. Rottenborn,
yes, Judge King.
Ms. Rottenborn, this Judge King.
Good morning.
It's your position, we need to, that is, the court needs to mind the record a little bit and see if your position's solid, even though the judge didn't articulate it.
I don't think that's necessary in this case, Your Honor. The judge articulated specifically that Burnley instructed Varner to collect money for him, and that is sufficient to apply the managerial role enhancement here. The court is, of course, welcome to review the record in its entirety and decide whether or not there's sufficient evidence to imply the enhancement based on other facts. And here the record would support that. But the reasons specified by the district court judge here are sufficient alone. In addition to specifying that Burnley had instructed Varner to collect money for him, and the support for that, by the way, is at JA 132, and it's not Varner's testimony, it's Knowles' testimony, Christopher Knowles, who said that Varner came to collect the money on Wayne's behalf. But the judge also found that Burnley had instructed his sister, Rebecca Burnley, to collect money on his behalf as well. And that is supported in the record at JA 84 through the testimony of Christopher Mays, where he testified that he had to pay Rebecca Burnley the money that he owed the defendant, Wayne Burnley. And the judge made that specific finding at JA 370 to 371 that Burnley had instructed his sister, Rebecca, to move the money on his behalf. And so it's the government's position that those specific factual findings, of which the district judge made 4, are sufficient to support the application of the managerial role enhancement here. I also note that in addition to the 4 statements provided by the district court judge, the PSR had 2 additional reasons for applying the enhancement, and all of the facts underlying the enhancement application in this case were uncontested by the defendant. Mr. Burnley did not raise any objections to the offense conduct in the PSR, and these facts about Varner having to collect money, Rebecca Burnley collecting money, and Varner collecting meth from the PVC pipes on Burnley's behalf were and remain uncontested by the defendant. I also note that the district court judge found that Burnley was a manager at different times of Connie Lehman, and the support for that can be found in the PSR at paragraph 55, which is JA 487, and in her own testimony from trial at JA 50 through 56. And although I concede that I don't think the managerial influence over Lehman is as clear or as frequent as the managerial influence over Varner, it does exist in the record and provides an additional basis on which to apply the managerial role enhancement. In short, the goal of the managerial role enhancement is to reflect the relative responsibility that Burnley played in this criminal enterprise. And here, the district court made a common sense judgment about his relative culpability by realizing that his status in the hierarchy was higher than Lehman, Varner, and his sister Rebecca Burnley, all of whom played a role in the day-to-day operations of this drug business, both before and after Burnley's arrest. Judge Keenan wrote in the Stephan decision that the significance of the evidence before us is not mitigated by the fact that in other cases affirming the imposition of the enhancement, we relied on substantially greater evidence of the defendant's managerial role. I would say the same is true here. I think there is abundant evidence to support the application of the managerial role, and although it may not rise to the level of the evidence in some of the cases cited by my opposing counsel, it is more than sufficient to not be clearly erroneous.
So I guess you don't think that Mr. Burnley is the Rodney Dangerfield of a meth conspiracy?
Respectfully, no, Your Honor. We do believe, although he was not the
Do you even know who? Do you even know who Rodney Dangerfield is?
I do, Your Honor. I would put myself somewhere in between, in the middle of my knowledge of Rodney Dangerfield between you and your law clerks. I'm perhaps not an expert, but I did appreciate my opposing counsel's reference in his brief, and I appreciated the chuckle that came with it.
So can I ask you, on a bit more serious note, that how you reconcile the holding in Chambers with what happened here? I mean, we seem to suggest in Chambers that if the district court doesn't go out of its way to consider all of the relevant factors for this enhancement, that we can't conduct meaningful appellate review. So what is it about this case that makes it different?
Respectfully, Your Honor, I think Chambers overstates the obligation that should be imposed on the trial court, and subsequent decisions of this court that postdate Chambers don't imply that same rigid level of expectation with respect to the commentary of the guidelines.
Excuse me, counsel, were any of those post decisions en banc?
No, Your Honor, they were not.
What makes you think they would overturn Chambers?
Correct, Your Honor. Of course, a panel of one cannot overturn a panel of another. But to the extent that opposing counsel or this panel is reading Chambers as to require a district court to review all 7 factors suggested by the commentary of the guidelines, or else this panel cannot conduct a meaningful review of the trial court's decision, I do not think Chambers holds that. And
the Chambers cautions us that we're not supposed to shouldn't have to hunt through the whole record to find a way to justify something that's not mentioned and grapple with by the district court.
Absolutely, Your Honor. And the trial.
But you're suggesting that's what we need to do. We can hunt and we can find. Maybe if we scurry through the record and cobble it together, we can say that this is managing. Because I find that he was a manager, that's not a finding of fact. That's just a conclusion. The whole point is we're trying to find out if he were a manager, to find that he supervised someone. That's not a finding of fact, really. That's a conclusion. That's for the court to determine, but it needs facts to justify that. The mere fact that you said she was with him when he was selling drugs, correct?
She was with him, although I do not think that supports the application of the managerial role enhancement. The government does not suggest that simply selling drugs or being present when somebody else sells drugs would be sufficient. And let me be clear here, in Chambers, the panel reversed, holding that the trial court's statement that the defendant was a supervisor at some level was not specific enough to allow for meaningful appellate review. But that is not the case here. Our trial court specifically found that Burnley, and I quote, instructed Varner to collect money for him and instructed Rebecca Burnley, his sister, to move money on his behalf. And those are specific factual findings that explain why Burnley was in a managerial or supervisory role vis-a-vis those individuals and those co-conspirators. This is not the case where the trial court just said he was a manager, hard stop, period, and this court can't do anything with that type of analysis.
He said he instructed her, correct?
Instructed Varner to collect money for him as part of the drug operation, yes.
Right.
And that's
somebody else said that was the case, right?
Yes. Yes, Varner testified, as did Christopher Knowles. And Christopher Knowles testified that Varner was collecting money from him on behalf of Mr. Burnley. The same testimony was given by Christopher Mays, saying that Mr. Burnley's sister, Rebecca Burnley, was collecting money on Mr. Burnley's behalf. So he supervised these individuals to collect drug proceeds on his behalf. I also know that it's consistent with the rest of the testimony that Burnley fronted his drugs and expected payment later. In addition,
I don't want to quibble over semantics, but I think it's very important here because in these cases here, that means years of someone's life in prison. But, I always thought supervising was more than just discrete acts. Like Mr. Walter said, he said, go get me some bubble gum from the store. And I did it 5 times. I'm not your supervisor necessarily. Supervision seems to comes with it. The denotation of it is that it involves to supervise, to be over someone, to have it's a relationship more than just an act. We have plenty of cases that driving along with someone, accompanying them while they're selling drugs, that alone is not supervision necessarily because they're with you. Say, hey, come ride with me, but I'm going to sell some smack. And you're with them. That doesn't make you a supervisor. Why are you there? Because he said, listen, the guy's over there, can you just hand me this right here while I'm here? So we're turning these cases into just everything that someone said to you and you did it means you're a supervisor. These cases have to be very careful. There is something about the rule of lenity and those kind of things. I know you can do it with hearsay. We're stretching. I think the framers would be just mortified that you can use, not in this case, but acquitted conduct. We have stretched the whole idea of constitutional protections to the point where it's almost unrecognizable.
Yes, Your Honor, I understand that.
You say he instructed. You're saying that. Not only you, but the judge said it. But was that the testimony that was instructed that said she came and collected the money? I bet that's what they said. That was it. He instructed. Was that the word that the person used?
Respectfully, Your Honor, it was indeed. I believe it was that you were told to do this. And I actually do believe that the word instruct was used at one point. I'm confirming right now in the record.
But this, first of all, this is a person who wasn't the person, right? This is somebody else saying this, right? It's not Varner saying it, right?
Varner's testimony, yes, is at JA 111, where she explains that Burnley would purchase kilos of meth, bring it back to the home, break it down in ounces, and put it in Tupperware or PVC pipes, and then hide it in the woods or on the back roads near his house and all around his home. And that she would work with him to do this. And then he would tell her to jump out of the car and go get the meth that they had hidden when it was time to then distribute that meth. That was before he was arrested. And then after he was arrested, she was one of the people Burnley instructed to go find the meth that he had thrown out of the window when he was eluding police. But I want to emphasize here, these are not one-off instances or isolated directions that Your Honor is worried about. This is not the case where it is stretching the application of the enhancement too far. Mr. Burnley was a significant drug dealer who had many people running his operation for him and with him. And he would provide instructions and manage that operation on a daily basis. The record supports that not only did he instruct Varner to do these things, but that he at times instructed, for example, Donald, which was another co-conspirator, to go collect money from Christopher Knowles, that he had so much managerial influence that he controlled who came into the fold and who would work directly with his supplier, Mario, who was providing the kilos of meth. And that once he blessed a lower level street dealer to work directly with Mario, that the price of that meth would go up in order for Burnley to get his cut for making the connection. There was a clear hierarchy here. Mario was the primary distributor down to Burnley, who then had a variety of people, either as street dealers or as co-conspirators, helping him run this operation. But Burnley was calling the shots. He was the one exercising decision-making authority, as the factors suggest this court should consider, in terms of where the drugs were going, who was allowed to sell them, and when and where they were being distributed. So this is
Ms. Rottenborn, can I excuse me,
Yes,
you just went through a detailed recitation of the record that appears to amply support a finding with respect to the enhancement, and I get your point that this may not be what I'm about to say may not be this case, but let's say the district court in this case simply recited the language of the enhancement and said, based on the record evidence, I find that the defendant satisfies the enhancement. And you've got all this record evidence that the government would seem to say supports that enhancement. Would that be enough? Or does the district court actually have to make some findings about the evidence in the record?
Respectfully, Your Honor, the Fourth Circuit's case law on that point comes to different conclusions depending on the case you read. And there are cases.
So they go back to Chambers?
Chambers predates Holmes from 2010 and Stephan from 2013.
Chambers is in 1993.
It's correct.
That's early on in these guidelines. That's very early in these guidelines. And who's the author of Chambers?
I'm checking, Your Honor.
Which judge wrote that? Pardon?
I think it's Judge Williams.
Judge Williams.
Yes, Your Honor. Yes, that's right. Judge Williams.
Okay.
That's correct.
And Judge Williams Judge Williams' opinion then is the guiding light for this. The other opinions can't change, as Judge Gregory pointed out, unless you got an in-bank case. Judge Chambers is what controls.
Chambers is a case that speaks to the topic, but it holds that when the judge found that the defendant was a supervisor at some level and made no additional findings, and there was not undisputed facts in the record that made that finding clear, that they sent the decision back for the judge to assess the factors and make more specific findings on the record. But the majority of the decisions that I was able to identify and that I have reviewed have made the holding that this court can affirm on any basis in the record. And that means that because it is a factual finding and not a legal application of the guidelines, that even if the district court does not clearly articulate his reasons for the application of the enhancement, if based on the undisputed facts in the record, this court finds that the enhancement would be satisfied, this court can affirm. And that is the holding in Holmes and Steffen and Bartley and all of the cases from the last two decades that are cited in Burnley's brief. Now,
I mean, counsel, then, and I follow your reasoning, but doesn't that really mean that as an appellate court, we're doing the sentencing ourselves?
no, Your Honor. To the extent that there would be disputed facts or lack of clarity in the record to conduct a meaningful appellate review on this issue, I understand why the panel would send it back. But just like you look at a sufficiency of the evidence claim, here, when you're looking at a sufficiency of the evidence to support the application of a factual determination that results in a sentencing enhancement, this court can look at that record just as you would a trial record and determine whether or not it as a whole supports the factual finding.
Yeah, I always thought the sufficiency of the finding of fact is what we're looking at that supports the enhancement. But now you're saying we can do it by, our job is in the first instance, look at the record, which had not been, for example, looked at the district court, or at least indicated that he or she did, and then we do it. So that means we're sentencing them in the first instance, really. We're taking a cold record. And as you said, and I have no doubt that you represented properly the record, what you just told us, but we're now hearing that as if we were at the sentencing ourselves, and then we're making that finding. I thought when you said we're an appellate court, and it had to be enough for our review of what the court showed that it did. And that's what Chambers is talking about. And this accretion you talked about in terms of, I call it case law creep. In a sense, because but it can't change the basic idea that I think Judge Diaz hypothetical to you or question to you was just spot on. If all the judge says that I'm giving the enhancement because he was a supervisor, that's all, then that's fine, as long as counsel, brilliant counsel like you for the government can come in and point to all of these places in the JA. And then from the first instance, we say, hey, you're right. I think that is supervision. Oh yeah, that one too. So that's what you think the law of the Fourth Circuit is devolved into?
Your Honor, I see that my time is up. May I answer your question?
Absolutely, absolutely.
Thank you. I first want to emphasize that that's not this case. Our trial court made specific factual findings about two individuals who had to move money on behalf of Mr. Burnley as supervisees or as people he was managing. And so this court does not need to reach the question that Judge Gregory, you're concerned about in this case, because our trial court judge made specific factual findings.
So do you agree that we can be left to only the ones that he made, not all the ones you're talking about?
Yes, Your Honor, absolutely.
So you can see that, okay. All
yes,
right.
and that is supported by this court's decision in Kellum from 2009, where the court found that it was enough that the defendant had fronted drugs to his resellers and had established a place in the hierarchy, because that showed that the defendant retained some level of control over how and where the drugs were going to be distributed and how the finances would work.
Well, see, that's another thing too. Again, we've gone so far. Fronting someone's drugs doesn't mean you're a supervisor. That means if you take that analogy, then the banker is the supervisor of the person who got a loan from them, or it's not supervision. I mean, these are conspiracies, right?
You're not supervising the individual to whom you fronted the drugs, but if you are a drug dealer and you front the drugs to John Doe and then you send Jane Smith to go collect the money from John Doe as your standard operating practice as part of your drug business, and Jane Doe has to do what you say to bring the money back to you because that's her role in the drug enterprise, then yes, that is a managerial role that the person higher up in the hierarchy is executing upon. And that is what this court has held in Holmes and in Kellum and in Steffen and in Bartley. And this case is right in the heartland of those cases. And based on the specific factual findings that our trial court made, this court should affirm the imposition of the enhancement, find that it is not clearly erroneous, and affirm the sentence in this case.
Thank you, Ms. Roddenborn.
Thank you, Your Honors.
Mr. Walters, Ms. Roddenborn is giving you a lot to say, and you don't have a lot of time, but get to it.
Well, court reporters always tell me I talk too fast, so I will see what I can do here. I would invite the court to look at Judge King's decision in Lamas, which is cited in our briefs. It deals with this question exactly. In that case, the government conceded error on enhancement. And it said the government seeks to salvage the district court's application, in that case of the vulnerable victim adjustment, by relying on other aspects of the record which the court did not address. And it then shuts that down. It says we in these circumstances, application of the vulnerable victim adjustment cannot be justified simply because there might be some evidence in the record not addressed by the sentencing court supporting that particular enhancement. So Lamas is a 2010 decision. Judge King wrote it. I'll defer to him. But I think Chambers is alive and well. And and the Lamas decision relies on Carter, which said the same thing. The court is not allowed to go look at other places in the record on these enhancements. The district court needs to make factual findings. Trial counsel objected to the conclusion, so the court needs to articulate the conclusion it's reaching, the facts it relies on to support that, and the government is not allowed, and this court is not allowed to go look elsewhere in the record for it. With respect to that, I just want to then address a couple of things. So the government says that Burnley instructed her to go get the drugs she threw out the window. Now, of course, that is not anything the district court relied on, so I'm not going to go too far down this rabbit hole. But all that she says is, did he call you and tell you anything? Yes. He was trying to tell me where to find what he had thrown out. She doesn't say he told me to go get it. She doesn't say he directed me. She doesn't say I felt like I better do it or my boss was going to be mad at me. She wanted some pills. She was a drug user. He told her where some stuff was. And Judge Greg, you had asked the question, does anybody ever use the word directed? No, certainly not the people who were actually claimed to be directed. But if you look at the testimony of the other people, it's like Your Honor pointed out, people came and said, you're supposed to give me money. They didn't tell any of these people, Burnley told me to come get money from you. I feel compelled to do it. He's my boss. I think Your Honor's pointed out the natural thing, this is again what Your Honor got it in Wilson, in drug conspiracies, people are asking people to do stuff all the time. And people do it to get along. And I think the important point Your Honor has made, and again made in Wilson, is that these are kind of subtle things. And the district court needs to move beyond this person told this person to do it and they did it, and get into figuring out why that person did it. Was it a gang member helping out another gang member, or was it because it was the gang boss, and if I didn't do it, I was going to be in trouble? And I think that's really what, and this, the First Circuit articulated this probably the best, is what we're looking at is, are there going to be consequences? This is sort of the trying to remember the name of the case, that involved the call center down in Costa Rica. I think it may have been Lamas. Who's the enforcer here?
That was Lamas.
Yeah, Lamas. Who's going to put the hurt on somebody if they don't follow this direction? That's a supervisor. There are consequences for me ignoring what my supervisor tells me to do. If I don't do something, as happened all the time here, and nothing happens, I would submit, Your Honor, that it is clearly erroneous to conclude that that person is a supervisor. And this is where actual articulation and discussion by the district court comes in. The district court would say, I found that this person didn't say that they were told to do this, but on the entirety of the circumstances, I conclude that this person wasn't just doing this because they were another drug dealer. They were doing this because they really felt that Burnley was the boss. So I do think that the court has been articulate on a number of occasions that we cannot, at the appellate stage, go and find other evidence in the record to support the conclusion. It has to be the facts that the district court cited in its ruling on that issue. And Your Honor is completely correct, Judge Gregory. The district court didn't actually make a factual finding. It just made a conclusion. If that was a complaint I was answering, I would say, well, that's states a legal conclusion and no affirmative response is required. Just to say he's the supervisor, sure, he says directed to move money, but then you get into this issue of no factual findings were made on that. And to the extent you can go and look in the record, it would be limited to that.
Mr. Walters,
certainly.
I'm sorry. When you say the court didn't make any factual findings, I mean, there were at least two in this admittedly very brief explanation. One, that he instructed Varner to collect money for him and instructed his sister, Burnley, to move money on his behalf. So I guess the question is are those findings, those are factual findings, don't you agree?
Yes, and I would submit they're both clearly erroneous. You will search the record in vain to find anybody.
Okay, but that's a different point. But I mean, he, Judge Moon, did make findings, and so the question is, two questions. Are they supported by the record? You say they're not, but if they are, is that enough to support the enhancement? And I guess you say on both points, no.
No, and to deal with the second one, Your Honor, it's because there's a number of other factors that the court has to consider. I agree with government counsel that I don't think there's a Fourth Circuit decision that says the sentence must be reversed if all 7 factors are not articulated or discussed. But I do think that the court needs to at least indicate that I'm aware that those factors are out there, and I'm concluding that this one really controls the day, or the other ones don't apply, or they help, or they don't help. It's a multi-factor test. And I think simply to come in and say, I find these 2 things, that's one of the factors, arguably supports one of the factors, good enough for me. I think this court's decisions require more. And again, I think the record simply just does not support those conclusions to the extent that that's what they are, Your Honor.
All right, thank you, counsel. I note, Mr. Walters, that you're court appointed. I just want to say a special note on behalf of the Fourth Circuit to thank you.
Certainly, Your Honor. Thank you.
Appreciate the help of lawyers like yourself who take these cases and help us deal with these difficult issues. And Ms. Roddenbaum, you're certainly able to represent the United States here today as well. Thank you both for a very, 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 very strong arguments and very difficult matters that are very important to our criminal justice system. Thank you.
Thank you.
You can't come down and shake your hand and say that our appreciation is nonetheless heartfelt, and we appreciate it. Thank you so much. We hope that you will both be safe and stay well. Take care.
Thank you, Honors.
All right. Bye-bye.
Bye.
Thank you.
All right. Thank you. And the panel want a break, or we'll go. Everybody's here. Mr. Moss, you may proceed.
Thank you, Your Honor. May it please the court, my name is Aaron Moss. I represent the appellate, Mr. Johnson, in this appeal. My colleague, Ryan Kennedy, is also present. He represents the co-appellant, Ms. Stewart. The appeal raises 6 issues, and I'll be covering 1, 2, 3, and 6. Mr. Kennedy will take 4 and 5. But the issues in this appeal are intertwined, and their cumulative effect compounded the prejudice against the defendants, caused their case to become corrupted, and deprive them of a fair trial. The misconduct, the error, and the prejudice towards the defendants in this case started early, but it was pervasive throughout trial, pretrial, and sentencing. The first issue is the prosecution's failure to disclose and preserve Mr. Mercado Medrano's cell phone. This violated defendants' due process rights and denied them a fair trial. Now, due process violations are reviewed de novo, and a de novo review in this case shows that defendants' due process rights were violated through the government's failure or refusal to disclose its possession of Mercado Medrano's cell phone until after they had already failed to preserve it. Specifically, the government violated the defendants' due process rights on this issue when they suppressed the cell phone by failing to provide the defendants with even inquiry notice that they ever had possession of it until after they had failed to preserve it. That cell phone was material to the defense. It contained impeachment evidence, and it contained potentially exculpatory evidence.
Mr. Moss, how do we know that?
How do we know that it was material, that it contained impeachment evidence, Your Honor? The phone was objective evidence, in contrast to the possibly biased and certainly conflicting testimony of witnesses like Levi Conley, Robert Haynes, Cody Scott, BL. And there's a reasonable probability, which is what's needed for materiality in this case, that the phone would have clarified conflicting testimony or undermined the confidence of these witnesses, specifically when they were testifying about their texts with Mercado Medrano. Levi Conley's testimony dealt with his texts directly to Mercado Medrano, and that was JA, I believe it's around 959. Robert Haynes' testimony about his communications with Mercado on his phone. BL's testimony about text between him and Mercado Medrano. relevant as impeachment for their testimony and Larkin Hike's texts regarding marijuana use versus the lack of marijuana metabolites in the drug tests. What's important here is that the record indicates that Mr. Mercado Medrano shows up at the Motel 6 with a bag of substance that he claims to be marijuana. There's testimony that marijuana was smoked that night. However, no toxicology result for Mr. Mercado Medrano actually contained any indication that there was marijuana metabolite.
But Mr. Moss, didn't the government make available at least some of the texts related to this so-called lace blunt? And that was there. So I'm not exactly sure what else the phone would have contributed to that.
The government made available screenshots that it took from Larkin Heights' phone that showed texts between her and Mercado Medrano. Without Mercado Medrano's cell phone, it can't be said whether or not those texts were manipulated before they're shown to the government. But this evidence.
What do you mean by manipulated? What does that mean?
Well, Your Honor, text can be deleted off of a phone and then shown to the government. We're not certain if we got the whole story there. Certainly we did not, because there were texts before that time. But what this evidence, what the cell phone is particularly important for is impeachment of the witnesses who testified to texting Mercado Medrano that night. It is also potentially exculpatory. And Your Honor, the only reason I cannot stand here before you and argue that the cell phone contained exculpatory, aside from the impeachment evidence, is because the government never conducted an analysis of it. And they, by failing to disclose they possessed it until they failed to preserve it, they prevented any outside analysis from defense counsel. Now,
this Judge King, Mr. Moss, my understanding, they gave the phone back to the family after the guilty plea.
Your Honor, they gave the phone back to the family before the first plea hearing, and that, of course, that plea was rejected. So, again, there's no documentation.
I thought the guilty plea was entered before the magistrate judge. They gave the phone back after that, and then the district judge rejected the plea agreement.
That is accurate, Your Honor. Based on what.
All right, but did they give it back to the family after consulting with the prosecutor?
No, Your Honor.
Was this a decision made by the investigator, or do you know whether the record shows?
Your Honor, a huge issue in this case is that there is absolutely zero documentation from law enforcement about this cell phone. There's no documentation.
So you don't know, the record doesn't show when it was given back or who made the decision to give it back?
It doesn't show anything. There's no investigation report, property disposition report, notice, memorandum, correspondence, communications, documents about the seizure, the receipt, possession, or the return of the cell phone. There's
no testimony or affidavits about it at all?
Nothing, Your Honor. There's a complete lack.
How do you know Counsel, how do you know they had it?
Well, because they admitted that they had it. After the plea was rejected, a supplemental discovery request was submitted by the defendants, and one of the requests was this cell phone, and they admitted that they had it, even though there was absolute discovery.
Absolute. What you trailed off? You said there was no absolute.
Oh, I apologize, Your Honor. The government admitted that they possessed this cell phone. However, that is the only evidence of their possession. Again, there is nothing in the record.
So at the same time they acknowledged, they had it, they were also informing you that they didn't have it.
That's correct, Your Honor.
Was it given back? Is it your position that the cell phone was returned to the family by virtue of negligence on the part of the officers in the government or in bad faith?
Your Honor, I think it amounts to bad faith. And I think that United States v. Elliott, which was decided by a district court within the Fourth Circuit, helps to demonstrate why these actions amount to bad faith. Law enforcement basically has no good faith basis for its reckless disregard and total failure to follow any established procedure here. The law enforcement officer who admitted to taking the phone, he had 25 years of experience. He knew the proper procedures. He testified those procedures were documenting every step, preserving evidence, clear chains of custody, including noting disposition. He stated that when he does not write something down, it did not happen. Then he admitted that there's no written documentation about seizing, receiving, possessing, analyzing, or disposing of this cell phone. There are zero records of law enforcement possessing the cell phone. And those zero records show that he acted in a manner contrary to applicable procedure in regard to this evidence. He, Your Honors, that he did not conduct any analysis of the phone. There was no attempt to assess its exculpatory value, even though it had material value that was apparent. The record is completely devoid of evidence that Officer Bean acted pursuant to any applicable controlling procedure. And that is important because United States v. Elliott found that bad faith exists when conduct is knowingly engaged in when it's reckless. That failure.
Do you have to show bad faith, or is negligence enough?
Well, Your Honor, if the court believes that there was impeachment evidence, then I don't think we have to get to bad faith. However, if the court only believes that this cell phone possessed potentially exculpatory evidence, then we do need to show bad faith. However, I think bad faith can be shown, and as Elliott found, bad faith is shown when law enforcement acts in a manner which was either contrary to applicable policies and the common sense assessment of evidence to be reasonably expected of law enforcement, or was so unmindful of both as to constitute the reckless disregard of both. There is a showing of objective bad faith. Elliott held that the loss of evidence without first attempting to assess its exculpatory value constitutes bad faith, because the controlling regulations clearly teach that there's a critical link between due process of law and the destruction of evidence, and clearly require that an assessment of evidentiary value be made. That evidence, like Elliott, none of the controlling regulations were followed here. The conduct was reckless.
What remedy did you seek from the district court as a result of the absence of the cell phone?
The remedy I sought was a motion, or that Mr. Johnson sought was a motion to dismiss for failure to preserve the cell phone.
Did you seek anything less than that?
Well, when the court denied the motion to dismiss, Your Honor, we sought an adverse inference jury instruction, which the court.
Okay, there's two things. Did you try to get the phone back?
We did try to get the phone back, Your Honor. We subpoenaed the phone from the family. The family came and testified that they had lost the phone after the government had given it back to them. What was also interesting in this case, and I think it highlights the importance of documentation and the shortfalls of the law enforcement not having any documentation about the cell phone in this case, is that the family's original testimony was that they had given the government 2 cell phones that belonged to Mercado Medrano, but only one was returned. So there was confusion throughout the record about the cell phone, and I think that frankly the complete lack of documentation on the government's part for this cell phone is reckless. It is completely against the controlling regulations, and it amounts to bad faith. These are the same.
Did you ask for? You say you asked for an instruction, like a spoliation instruction?
That's correct, Your Honor. We asked for,
and it was denied.
And it was also denied, Your Honor. Yes. We were. The jury should have been told that they were permitted to infer that the government feared to produce this phone based on the fear that it would have exposed facts unfavorable to the prosecution. The district court refused to give that instruction. I understand I am over my time, and I am happy to continue to go on. I would like Mr. Kennedy to have an opportunity to address the court. But if there are any additional questions with regards to issues 1, 2, 3, or 6, I am more than happy to answer them from the court.
All right. Thank you, Mr. Moss. Mr. Kennedy?
Thank you, Your Honor. May it please the court, my name is Ryan Kennedy. I represent the appellant, Ms. Stewart, in this case. I'm going to start by arguing with a motion for acquittal, which is something that only has to do with my client, not Mr. Moss's client. And in doing so, I have to argue the facts in the light most favorable to the government as per a motion for acquittal. So to be clear, I'm not admitting that this is actually what happened, but I'm taking the facts in the light most favorable to the government here. In that light, there were 2 drug sales. In the first sale, Ms. Stewart was seeking marijuana, and Johnson and Stewart met Mercado in a motel room, where then Johnson sold drugs to Mercado, Conley, and BL in exchange for marijuana and cash. Stewart then actively participated in the light most favorable to the government, including cutting lines, and then Johnson, Stewart, Mercado, Conley, and BL were all participants. Mercado, as part of this first transaction, ingests a line, and Stewart acquires her marijuana. At that point, the first transaction ends, and then there's a break. During this break, Mercado felt fine. He walked around without difficulty, the evidence shows. He also drove Johnson and Haynes in a car to an ATM. And then he properly operated that ATM to obtain more cash. And then he was able to drive back to the hotel room in a span of some time while Ms. Stewart was sitting in the hotel room. Then at this point is when the second sale kicks off. Mercado and Haynes pay Johnson for an 8-ball, and Mercado does not partake of the 8-ball in front of them, but puts it in his pocket and leaves. Haynes participates, but Conley and BL do not participate in this second transaction. After the second sale, Mercado drives other people home. Then he drives to Waffle House. He orders food, and then he drives away. Sometime hours later, he is found dead with morphine in his system. How do we know these are 2 separate transactions? Well, we look to the Letterlow case that this court decided back in 1995. In that case, which approved of the U.S. v. Washington case from the Fifth Circuit, there were 2 drug sales. It's almost directly on point here. There were 2 drug sales, and this court said, and I'm quoting from this court from Letterlow, Letterlow's 2 drug sales, although perhaps occurring pursuant to a master plan to sell crack cocaine as a business venture, can hardly be said to constitute a single occasion. If we went into a drugstore to purchase aspirin, the transaction would be complete once we left the store with the pills, even though the drugstore was still open for business. Similarly, each of Letterlow's drug sales was a complete and final transaction and therefore an independent offense, unquote. So the key is that we're distinguishing one event versus 2. And how do we do that? Well, the key question we have to ask ourselves is, does the person have an opportunity to pause and decide whether to engage in further criminal activity? That's what this court has said. So in this case, there is certainly a pause for Ms. Stewart, because she was, after this first transaction, she's sitting in the motel room while other people go and get cash and then come back and engage in a second transaction. And as this court has found, mere presence when a drug deal or some other illegal activity is going on is not enough.
Mr. Kennedy, can I ask a question?
Absolutely, Your Honor.
As I understand it, the government simply needed to prove that Stewart aided and abetted the heroin sale that resulted in the death of Medrano. So, I mean, even if we concede the point that these may have been 2 separate drug sales, why isn't the evidence that showed that, for example, that she was the one who used her email address to reserve the motel room, she carried the duffel bag full of drugs into the room, she helped lead these kids into the motel, she remained in the room with Mario Medrano's friends while Medrano and Johnson went to the ATM to withdraw cash and then remained in the room when Medrano paid Johnson for the second batch of drugs. Even putting aside the fact that mere presence isn't enough, we have a lot more than mere presence here. So why does it matter whether or not they're distinct sales? If she was, I mean, she was in for, it seemed like she was in for a penny in for a dollar here, because she began as a co-actor with Johnson in this case.
Well, Your Honor, thank you for the question. I think it's very important to distinguish that what the court just listed as her active participants all happened prior to that pause I talked about. After the pause, that's when she was merely present, and that's our position. What
do you consider to be the pause? What's the pause?
The pause, Your Honor, is when the first transaction had completed, and then several of her co-defendants, then Medrano and a couple of other people got into a car, and Medrano drove them to an ATM, where then he operated the ATM to get cash, and then come back to the motel room to complete a second transaction.
Right, but your client remained in the motel room with the other kids. She didn't leave.
Correct, Your Honor, but she had that pause to decide whether she wanted to engage in further criminal activity, and the evidence doesn't show that she did anything other than just be merely present during that second sale.
What's the evidence that she did anything with respect to the first sale?
Well, in the light most favorable to the government, she cut lines for people to consume the drugs from the first sale. And also, as Your Honor indicated, the evidence in the light most favorable to the government would show that she was carrying the duffel bag and things like that prior to the first sale.
Why do you keep saying in the light most favorable to the government? That's what the facts are here, because they won the case. We know that.
Well, Your Honor, I'm just not. I apologize.
Well, you have to accept those facts. You have to accept those facts. We know that.
Correct, Your Honor. I have to accept those facts, but I was just clarifying that I'm not admitting on behalf of my client that that's really what happened. But yes, for the purposes of the appeal, that's the facts we're working with. Yes, Your Honor.
But Mr. Kennedy, she's shown on the video what you call her presence. You're saying that's just presence. But don't you have to look at that presence in the context of her prior involvement in terms of you splitting those two events? If all you had was that second one was just presence, it's different. But having involvement of cutting the drugs and all those things Judge Diaz talked about in terms of the room and being with the young people in the interim, the trip, and then the second part you said is only presence, but that's in the context of all the other involvement, isn't it?
Well, Your Honor, as I said, I believe that there was that pause.
Yeah, but no, you're saying pause, but this temporal pause is at best minutes, right? It's not days, and it's in the context of the actual involvement, just recent involvement, correct? In the same res gestae, you say, as they said in Latin, the thing happening, isn't it?
Well, Your Honor, if I remember from the record correctly, it was about a 45-minute pause.
That's what I'm saying, minutes. That's why I did say minutes, didn't I?
Yes. Yeah, yes, you did, Your Honor.
Okay.
And but like I said, our argument is that pause was legally sufficient to make them two separate transactions, and that she wasn't involved in the second transaction. If I may just very briefly, because I see I'm over my time, just quickly address the other argument that I'm addressing, which is the prosecutorial misconduct argument, when the prosecutor made a false statement misrepresenting its own witness's testimony in rebuttal on closing argument, which undercut one of the elements of the case, which was the but-for element. And
was there an objection to that? Was there any objection to that so-called misstatement by the prosecutor?
No, there was not, Your Honor.
So you're raising a plain error point, right?
Well, Your Honor,
about a closing argument.
Yeah, Your Honor, yes, we're under the case law in this circuit. We are saying that this error was so obvious that the public reputation integrity of the judicial proceeding was impaired, which is
you should have objected and had the judge give a corrective instruction or something.
Well, I was not trial counsel, Your Honor, so.
Yeah, but
Well, that doesn't make any difference. You're the only lawyer she has. So
Absolutely.
Right now, you're the lawyer.
I cannot give you an explanation, Your Honor, as to why no objection was made.
But we can't tell you about the law. One of the problems you have is that you're talking about an error that was not made, or the objection was not made, that you now say was obvious. That belies by the fact that it wasn't helpful somewhat that no objection was made. But moreover, plain error is a tough standard. But also, this is not even evidence. It's closing argument.
Well, and I understand that, Your Honor, and I would point out in the Werner case, this court pointed out that a defendant is sometimes not required to make a contemporaneous objection to, because in order to do so, might have only emphasized the impermissible point, antagonized the jury. And what I think is particularly
Mr. Kennedy, I'm sorry. Go ahead, Judge King.
I was going to say, we'd have to assume that the lawyer, your predecessor, didn't make the objection because he didn't see fit to make the objection, that it was a trial tactic. He didn't want to emphasize the point, as Judge Gregory said. You go ahead.
Judge Diaz?
Well, I was simply going to say that there certainly might be a tactical reason for not making the objection in front of the jury, but at some point the objection has got to be preserved, and it wasn't here. And I guess the other point I would make is isn't it, I mean, the judge in this case, I believe, gave an instruction to the jury as part of the overall charge that the arguments of lawyers is not evidence, and it's up to the jury to recollect the evidence as best they determined it. And so it seems to me that instruction at least goes a long way in ameliorating whatever potential harm might have occurred in this case with respect to that single misstatement, right? It was just one time that the prosecutor misspoke. Is that right?
Yes, Your Honor. It was one time that the prosecutor misspoke, but the statement actually was that she, like I said, she essentially called Mr. Moss, who was trial counsel, a liar by saying that when he said in his closing argument that codeine metabolized into morphine, which was being asserted to show reasonable doubt as to where the morphine came from, which led to Mercado's death, because the evidence also showed that he was carrying around a bottle of codeine and drinking it that night. Then she said that what Mr. Moss said to you is incorrect, that codeine does not turn into morphine. Morphine turns into codeine, which was completely contrary to what her own science experts said. That was contributed testimony. And so I think this is particularly egregious because it was done on rebuttal. So the defense had no opportunity to address the jury again after that. And also because it undercuts the but-for cause and essentially cuts the defense's legs out from under them. And as this court has found before, a prosecutor has a higher duty than a typical lawyer does, because they are an arm of the state. And so what they say is given a certain sheen by a jury above and beyond what maybe another lawyer would say. And so that's why I think this is particularly important. And I see I'm over my time, so I'd be happy to keep answering questions, but otherwise I'll wait.
Thank you, Mr. Kennedy. Mr. Hellman?
Thank you, Your Honors. May it please the court, my name is Tim Hellman. I represent the United States in this matter. In this case, the defendants acted together, traveling from Baltimore, Maryland to rural Martinsburg, West Virginia to sell heroin. They had no other personal connections with West Virginia or the Northern District of West Virginia, other than to look for a place to sell drugs. On May 28, 2016, defendant Johnson sold heroin to an adult at a local strip club. A couple hours later, that adult died. Only 2 days after that, both defendants worked together to sell drugs to some teenagers who were out looking to experiment with cocaine that night. Both defendants lied to the teenagers and told them that the drug they were selling was cocaine, when in fact it was actually a bad batch of heroin. One of the teenagers who took the heroin died of an overdose as a result of that. The defendants were convicted at trial and now raise 6 allegations of error. I'll go ahead and jump right into the issue of the cell phone. And to address the comment that Judge King made earlier, I think Judge King had asked about whether there was any record about who gave it back, when it was given back. so forth. The record was thoroughly developed on that. It was investigator Brian Bean who had possession of the cell phone. After the defendant had entered a plea of guilty before the magistrate judge, is when investigator Bean acquiesced to the requests of the victim's family and gave the cell phone back. It was only after all parties believed in good faith at that point that the case was over, the plea was entered, there was going to be no further litigation. That's when investigator
you're saying the defendants were in on it and they agreed to give it back?
No, they didn't, Your Honor. But I think
you said all parties. You said all the parties agreed to give it back. Now that's
I'm
right
sorry.
Or wrong.
Well, I misspoke then. That's I didn't mean the defendant. What I meant by that is
the defendants didn't know. The defendants say they didn't know anything about the cell phone. You might have had maybe all the prosecutors and the investigators agreed to give it back.
Yeah,
is that what you're saying?
No, Your Honor, I don't think that's entirely accurate because the defendant did have possession of several screenshots of text messages that involved the victim's cell phone. So the defense
did they know it was did they know that those screenshots were that came from a cell phone that had never been identified to them, or they didn't know anything about? There were other cell phones involved here.
Yes, Your Honor. I'm not sure that was ever made clear. And
they said that they didn't know anything about this cell phone. Is what was the way I understand the record. Until after the plea was rejected, is when they found out. And then they made a supplemental discovery request after the plea was rejected.
That's correct, Your Honor. And in that supplemental discovery request, they mysteriously ask and say, upon information and belief, we would like a copy of the cell phone extraction or an opportunity to examine the victim's cell phone. So I think that
we don't know what they based that on then. Okay. Maybe
that's correct.
They had a suspicion of some kind.
And I think that's because
the record's not fully developed here about this cell phone for some reason. But the thing was given back. Was it given back? You're saying it was given back intentionally then, not by accident or negligence.
Well, it was given back intentionally by investigator Brian Bean, and there was some testimony at the pretrial
and
hearing.
You all knew the investigators and the prosecutors all knew that the case wasn't over. There'd been no sentencing. There'd been no appeal. And a criminal case isn't over when you take a plea under agreement to part of an indictment, and the sentences, and there's a pre-sentence report ordered, and the sentence is not made. So there's no reason, no argument to be made that this case is over. It should give away the evidence.
Yes, sir, that's correct.
Even if the judge had rejected the plea, we might have reversed it on appeal and there'd been a trial. This doesn't make any sense to me. I mean, I got kicked around on the defense side and the prosecutor side both with a lot of issues, and the whole thing here doesn't make a lot of sense about this cell phone.
Yes, sir, I would agree. It's certainly an unfortunate series of events. Investigator Brian Bean had the cell phone in his possession. There was testimony from the victim's father at the pretrial hearing because he was subpoenaed to the pretrial hearing because there were attempts made to get the cell phone back from the victim's family. And the victim's father testified that they had contacted Brian Bean numerous times asking him for the cell phone because they were afraid that perhaps it was going to be lost or erased. And you had a grieving family who had just lost a son, and they just wanted the pictures of their son off the son's cell phone. They just wanted the contents of that cell phone. And so, again, this just really goes to the issue of bad faith. Was investigator Brian Bean acting with bad faith when he gave it back? And I think the evidence is no. He had a reasonable belief. It was mistaken, but he had a belief that the litigation on the matter was concluded at that point. It had been in his possession. Judge Groh pointed out, the district court had pointed out that from the time of indictment to the time that the plea was entered was about 3 months. So he had it in his possession for about 3 months before he ultimately gave it back to the victim's family at the victim's request. But that goes to the issue of bad faith, that he wasn't acting in any way to gain a tactical advantage or to hide this from the defense. It was something that he felt like perhaps he had already provided those screenshotted text messages to everybody, and this wasn't something that was on an exhibit list, and he just returned.
Mr. Hellman,
Yes, sir.
Were you aware of it?
I wasn't trial counsel. Trial counsel, both attorneys are no longer with this district, but
They were aware of it. The U.S. Attorney's Office was aware of it, correct?
No, sir, not until the discovery request was made by defense counsel. That's when trial counsel got in touch with investigator Brian Bean and learned for the first time that he did indeed have that phone in his possession. And that's when the response to the discovery request was made.
Where did you think the screenshots came from?
I'm sorry?
Where did the screenshots come from?
The screenshots came when investigator Brian Bean met with the victim's girlfriend, Larkin Height, I believe her name was, and she took screenshots off of her phone that of the conversation between herself and her boyfriend, the victim Mercado Medrano, and she then forwarded those screenshots onto Brian Bean's phone. So that's where he got those exhibits, and those exhibits were provided to discovery and introduced in trial.
But did your office have an open file policy?
Yes, sir, we do. And I think that weighed into Judge Groh's decision at the district court level is that, there was some responsibility of due diligence on behalf of defense counsel to, hey, pick up the phone and call Brian Bean and ask that, or make an appointment to examine any exhibits or anything that he might have in evidence.
It's amazing. I would think that's the other way around. An open file policy, more the burden is on you. That you don't have to mince words and try to figure out that you give them the file, which includes what the investigator had. You do concede that the officer represents the government here, right?
I do concede that what the officer had in his possession is imputed to the government. Yes, sir.
Right. So therefore, it's open file. That means it's more of a duty on you to give it to them, not for them to ask for it.
I think it's just something that trial counsel just simply was not aware existed.
But I find it interesting that you started off, and rightfully so, this is a tragic case, there's no question about it. And you started off that way, and talked about things that really are not before really this court in terms of the issue. But I can understand a lawyer would do that. You sort of make a jury argument. That's where you started. But that argues against you here, because with a case where young people died, a young person died, and person before that, in a case where you are now saying a murder case, that you would treat evidence like this, such that you give it back. I mean, well, and that kind of thing, that because you're talking about, this is a case of science. Whenever you talk about someone ingested something that was at a level of toxicity and it led to their death, and these young people are together, it's in a social setting and phones, and so everybody knows who in and around a teenager, young people, it's the person, then there's the phone, and then there's the phone, then there's the person. They're unibodied. That's one of the first things you would look at, what the telephone, their cell phone, what happened, just like computers. I mean, you wouldn't give a computer back, which is that the victim's computer is there. Would you give that to the family before it's over?
Well, Your Honor, I think it turns on the issue of whether or not the computer or phone or whatever it is truly material to the case. And that's one of the issues that I think tilts in the government's favor on this matter, is that this phone wasn't favorable, nor was it material.
Well, if you want to know whether it's material, you're going to talk to the lawyers on both sides. And you're saying that it was given back without consulting with the prosecutor, without telling the defense lawyers that it even existed. Even though they'd already asked for discovery, they didn't know this phone existed. And then it's given back, and then it's gone by the time they asked for it. And then the plea blows up, and it's a tragic case.
Yes,
now
sir.
It's a tragic case procedurally on this point.
Well, and I think the reason why it's ultimately not a problem is because the phone wasn't favorable and it wasn't material. to any matter of consequence.
How is anybody supposed to know that? How in the world would anybody know that?
Well, I think for a couple of reasons. For one, because of the overwhelming evidence that the government presented at trial. I mean, there was over 20 witnesses that testified, including the 4 companions of the victim that night, Mercado Medrano, his 4 companions. They all testified. There was video surveillance footage that was produced that confirmed their testimony. Video surveillance was taken from Walmart and from McDonald's and from Motel 6, and it was pieced together in chronological fashion and presented to the jury. You had the infamous Snapchat photograph that showed defendant Stewart together with drugs on the table and Mercado Medrano with money in hand outstretched. You know, there was a testimony from the toxicologist and the medical examiner. It was a pretty strong case on behalf of the government. And the evidence, again, getting back to favorability and materiality, the evidence that the defendant claims would be material to the case was presented to the jury in other fashions. It was made available by other sources. Specifically, they got to introduce the screenshots of the laced blunt and the testimony from the 4 companions established what Mr. Moss is hoping is on the phone. And that's evidence that the victim tried to seek out other drug transactions that night. The jury heard that. The jury heard testimony that the victim made attempts to get marijuana from one individual and made attempts to get cocaine from another individual, but that both dealers ultimately stood him up, and they heard testimony that he wasn't ever able to acquire the drugs from those individuals. And then the jury got to see the text message about how he allegedly smoked a laced blunt. The jury heard testimony that ultimately, on the toxicology report of the victim, there was no cocaine in his system and there was no marijuana in his system. So anything that Mr. Moss claims would have been helpful that was on the phone, the jury heard that and rejected it, and it wasn't ultimately material to their decision. So
Mr. Hellman, the other component of Mr. Moss's argument was, in addition to this issue about the laced blunt, was he seems to suggest that the phone would have uncovered evidence to impeach the witnesses, the 4 witnesses who testified at the trial. But I don't think he actually ever described what that impeachment evidence is, and maybe that's the answer to my question. But how do you respond to that?
Well, I would respond by saying politely that I think that's simply a blanket statement regarding impeachment and favorability without any factual basis in the record. You know, as I said, 4 companions testified. Their testimony was corroborated by video surveillance footage. The timing of it all is corroborative of the testimony as well. You know, the video surveillance footage from Motel 6 shows Mercado Medrano, Stewart, and Johnson all entering the motel room first at 11:05 for you know what we've kind of been referring to here is the first transaction, and then the footage shows them, you know, after they left and got the money and came back to buy more drugs. The video footage shows them arriving at.
So, Mr. Hellman, can I ask a question about so what was the defense theory at trial? Was it that they never sold these kids any drugs, or that if they sold the drugs, that wasn't the cause of death? Which one is it?
I think it was the second one. In part was that they were arguing that the government couldn't show the but-for causation, that the drugs distributed by the defendants caused the death, and they were hoping, I think, to be able to point to the fact that, and again, I think their whole argument in this case rests on the theory that victim Mercado Medrano not only met with, but obtained heroin from another source that night. That's, you know, if there was some evidence in the record to indicate that.
And that's what they would say, I think, about something about that phone, that phone would have indicated whether there were phone calls made to some other drug dealer where they could have gotten the drugs from another source. And I can't understand if you got all this argument about it's not material and it wouldn't have made any difference and all that, you'd have been looked a lot better if you'd have agreed to the spoliation instruction and given them a fair trial with respect to the fact that the phone was gone. You could have
well,
made
Your Honor,
the very argument that you're making this morning could have been made to the jury in connection with the instruction on spoliation of evidence. And then if you'd have gotten a guilty verdict, you'd have had it resolved by the jury for you. But you objected to that instruction and the judge didn't give it. So now you're sticking us with trying to decide whether that's reversible error or not.
Yes, sir. As to the issue of the adverse instruction, that also, I believe, turns on whether or not the evidence was material and whether or not there was bad faith. You know, I would say I think the court ruled correctly.
I don't think it had to be in bad faith. It could have been accident. They could have been negligence. Make a mistake. You don't have to have bad faith to commit a Brady violation, I don't think.
Well, on the issue of an adverse inference instruction, the case cited in the government's brief, Hodge versus Walmart stores, indicates now, granted, that was a civil case, but nevertheless, this court stated.
That's a civil case, yeah.
Yes, sir, but it still examined the issue of whether or not a negative inference instruction should be given in a circumstance where one of the parties allegedly destroyed evidence, and in that case stated that a negative inference cannot be drawn merely from negligent loss or destruction of evidence, but requires a showing that the party knew that the evidence was relevant to some issue and that willful conduct resulted in the loss or destruction. And I think, put another way, that Hodge versus Walmart stores case was stating that, look, before a negative inference instruction is given, there has to be a showing of bad faith. There was another analogous case, United States versus Clark. Now, this was a criminal case, and that was regarding a negative inference instruction regarding a missing witness relating to some audio tapes. But in that US v. Clark case, court held that the defendant must make a showing at trial that it is reasonably probable that the missing evidence would have proven helpful in some way. And I think that's the issue of materiality. That ultimately there's nothing in the record to indicate that the victim met with and obtained drugs from another source that night. Pure speculation is not enough to satisfy a Brady claim. There's got to be something in the record in order to give the defense's argument some traction regarding materiality.
Well, when the evidence has been thrown away or given away and it's going, about all you got left is speculation and looking at the circumstances.
Well, sir, I think if there had been some testimony, perhaps from one of the four companions that night, if there had been some testimony to the effect of, hey, yeah, he said he not only wanted to get cocaine, he was looking for some heroin too, or that, yeah, he actually did meet up with somebody, then their argument would have some more traction. But all four of the witnesses were consistent in saying that drugs weren't obtained from any other source that night. And then that's also consistent with the toxicology report of the victim's substances in his bloodstream, that it only showed positive for heroin. There was no marijuana. So we know that the laced blunt issue was a red herring. And there was no cocaine. It was just heroin, the substance that the victim was not even seeking that night. I see I'm about out of time. I haven't really been able to touch on the other issues yet.
I wanted to ask you about, before you sit down, I wanted to ask you about the sentencing. Now the male defendant here, his IQ was what, 65?
I believe that's what the expert witness testified to at the sentencing hearing.
And was that adequately dealt with? They say it wasn't in the sentencing proceeding.
Well, Your Honor, as to the issue of whether or not defendant Johnson's sentencing was procedurally reasonable, I would argue that it was, because the district court gave an individualized assessment on that point. As this court has stated in the case of United States v. Harris, the sentencing court's explanation need not be extensive, but the record must make clear that the judge actually listened to, considered, and rendered a decision on these arguments such that this court can conduct a meaningful review of the sentence imposed for appellate purposes. And I think that's what we have here. When you look at the record, I think it's clear that the district court judge heard all the lengthy testimony from the expert witness that was presented. She gave all parties an opportunity to speak extensively on the issue, to make their full arguments, to make up their record. And then she gave very individualized assessment of the things that weighed into her sentencing decision. She didn't just go through a mechanical recitation of say, the 3553 factors, but she referenced things about the defendant being from Baltimore and having no ties to the Northern District of West Virginia, about the court.
Was that a proper consideration, the fact that they were from Maryland and Baltimore? Well, over in West Virginia? She did talk about that, and it was in the sentence being predicated on that to some extent. Is that proper?
I think so, because yes, Your Honor, I believe so. It's not so much that he's being punished for being an out-of-state defendant, but that the court found it significant that you have some individuals.
We got a recent case that talks about that, McCall or or something. Judge Richardson wrote. I believe, it was criticized, taking that into account.
Well, Your Honor, I would say the judge's sentencing decision was not punishing them for being out of state necessarily, but the court found that it, I believe, went to the issue of their criminal responsibility in this matter, that they just went to a rural town where they didn't have any family connections or nothing, and they went and they found kids. They set up shop. What's the
rural town? Martinsburg, West Virginia? That's pretty large place as far as West Virginia is concerned.
As far as West Virginia is concerned, yes, sir. I think it pales in comparison to some of the nearby metro areas. But you know, she pointed out that they came and they set up shop in a Motel 6 room to prey upon. She noted 3 children in our community that were ages 12 to 16, and then the victim, Mercado Medrano, who was age 18. That weighed into her decision, and that she found it disturbing that not only did they sell drugs the first time, but then, as she said, the defendant Johnson took Mercado Medrano back to the well for more, meaning that he escorted Mercado Medrano to the ATM machine to get $300 more to get more money. She also addressed his lack of remorse throughout the trial. And then this threatening note that he passed to his co-defendant during the trial, where he made a threatening statement about how, and he used the word BITCH, you better not turn your back on me. The court found that very disturbing.
Mr. Hellman, can I ask about the sentencing issue? So, as I understood the defense's argument, it was that at trial, Johnson's counsel made a plea for leniency in the form of both a departure and a variance based on the defendant's mental disabilities. And with respect to the departure, it's clear that in order to warrant a departure, you've got to show both that there is a significantly reduced mental capacity first, and second, that significantly reduced mental capacity contributed substantially to the commission of the offense. And it's clear that the district court did not find that in this case. But then you've got the separate question of a variance, and I have a concern about whether or not the district court then separately sort of kept these apart and considered whether or not that diminished mental capacity, whether she considered it independently of whether there was any causation element satisfied. In other words, that's just general mitigation evidence that the district court, it seemed to me, was required to consider, and she didn't say anything about that beyond finding that the departure didn't apply. So can you address that?
Well, Your Honor is correct that she did state that she did not find that the downward departure applied, and I think at that point did not grant the variance because the expert witness's testimony was not particularly compelling. Did
she say that? Did the judge say that?
Not expressly, Your Honor.
So how do we know that? How do we know that?
Not expressly. She didn't say it. Just say she didn't say it.
She did not say it. I mean, the record's clear that the sentencing transcript speaks for itself. You know, she didn't say it, but I think when you look at the things that she did say, that's when it makes clear that, you know, hey, the judge thought this testimony was baloney. And, you know, if this guy is so impaired, if he's so disabled mentally, how is it that he's sophisticated enough to hatch a plot to book a motel room over in Martinsburg, West Virginia at a Motel 6 and set up shop there and make 2 different sales and meet these kids at the McDonald's and to know enough to escort the victim, Mercado Medrano, back to the ATM machine to get more money? You know,
Mr. Hellman, what have you just said that's complex?
I'm sorry?
Have you said anything that's complex in terms of activities? Booking a hotel room, selling drugs, beating somebody at an ATM, you consider that to be complex activities?
I think for an average individual, it's not necessarily complex, but somebody who's allegedly to have a 65 IQ, somebody who's they're claiming to have a severe mental disability, I think those types of things would be complex for somebody if the condition is severe as the expert.
Isn't it alleged that someone helped him set those things up?
Well, Your Honor, there's evidence, specifically the email address that Defendant Stewart used to help secure the booking of the motel room.
Yeah, well, he had help then. That falls right in. You can't just take a part of the thing and just say it was favorable and ignore the whole context. He didn't do this alone. By your own allegation, Mr. Kennedy's client, he's talking about, right?
I agree with Your Honor completely on that. He was not acting alone. The 2 of them were in for a penny, in for a pound on the entire thing from beginning to end.
So then why would you tell us then that this evidence is clearly must be wrong? It's baloney, that's your word, baloney, because he did this by himself. This case is not that.
Well, if I said that he was doing it by himself, I apologize if that's the expression I used.
I asked you about what you said is complex. You said, well, for an average person, it might be, for a person with his hard, but the case said he was not doing it alone by your own facts, in which the case that was found here, right? So the point is that you agree that the court must address non-frivolous arguments for mitigation.
I think that's definitely the reason.
You say you think that's the law?
I would agree with you. That's the case law.
Okay, yes, sir. All right. So do you think that saying someone has a 65 intelligence quotient number is frivolous?
No, sir. I do not believe. I do not believe that was a frivolous argument that was made.
What evidence did you put on to contradict the expert testimony?
Well, I think it was the evidence that the judge.
That's an easy question. What evidence did you put on to conflict the expert testimony?
The government did not put on any expert witnesses of its own.
Okay. All right. Go ahead.
Let's see. I'm at 9 minutes and 30 seconds over. I believe.
You know exactly what your time is. Go ahead.
Okay. Thank you, Your Honor.
Unless there's a question from my colleagues, I'll give you a minute to wrap up because we did pepper you a bit.
I hadn't had an opportunity yet to address the issues raised by Mr. Kennedy. If I may have just a couple of moments to address that. On the prosecutor's misstatements, I think the court's already identified that has to be reviewed on a plain error analysis at this point because it wasn't objected to at trial. The comments were extremely isolated. As I was looking at that, for one, the prosecutor's comments were not a deliberately calculated, premeditated attempt to misrepresent the evidence or divert things from the jury. It was plain and simple. It was a heat of the moment brain goof that she made. She misremembered the evidence as it actually came out. As I looked at the rebuttal, now again, this didn't take place in the opening part of her closing argument, the main body of it. And I think that goes to show how it was heat of the moment, but it took place only in the rebuttal. It was an isolated point. Of the 5.5 pages of rebuttal transcript that she argued, only one paragraph was directed on this comment. I counted up the lines. It was 12 transcript lines out of 136 transcript lines of rebuttal. The remarks were very isolated, and the bulk of the government's argument was on the strength of the case. But the thing that I want to point out is if there was any potential issue by those 12 lines of rebuttal argument, it certainly would have been cured by the judge's instructions to the jury. The judge's instructions of the jury clearly state, and that's on Joint Appendix 1290, any reference by the court or counsel as to matters of evidence that doesn't coincide with your own recollection, it's your recollection which should control during your deliberations. So the jury was instructed on that. The jury was also instructed previously that questions, statements, and arguments of counsel are not evidence in the case unless they remain as an admission or stipulation of fact. And a third time, actually, the charge to the jury at the beginning of the case at JA 447, the instructions of the court as the jury is seated, she says, certain things are not evidence and must not be considered by you. And I'm going to list them now. 1, statements, arguments, and questions by lawyers are not evidence. So at 3 different points in the trial, the jury was instructed that, hey,
Mr. Hellman, I assume you've had several jury trials?
Yes, sir.
Can you tell me how many of them have you waived closing argument?
I've never waived a closing argument. There's been occasion that I've waived rebuttal when I didn't feel like I needed to beat a dead horse any further.
And you never have. I suggested probably most lawyers would never have because they're important, aren't they?
Yes, sir, they are.
Okay, all right.
Then I did want to also touch on the issue regarding the district court's proper denial of defendant Stewart's motion for judgment of acquittal. I do appreciate Judge Diaz already being very familiar with the facts on this. When viewed in a light most favorable to the government, there was ample evidence for which a jury could find that defendant Stewart aided and abetted the distribution of heroin that resulted in the death of Mercado Medrano. There was the issue of the email address that I already referenced. Evidence was presented to the jury, video surveillance that both defendants arrived at the Motel 6 together with defendant Stewart carrying the duffel bag that contained the drugs. The video and witness testimony confirms that it was defendant Stewart who initially approached Mercado Medrano at McDonald's, and she's the one that made the initial contact and arranged the first drug transaction. The video surveillance shows Johnson, Stewart, and Mercado Medrano together leaving the McDonald's and then walking across the street over towards the Motel 6 room. The video surveillance shows they entered that room at about 11:05. The video surveillance, the witness testimony from the 4 companions established that it was Stewart who actually showed them how to use the drugs because these were teens, they weren't too familiar with it. She cut the drugs with a credit card and then taught them how to roll up a bill and snort it up their nose. It was Stewart who waited behind with the 3 boys in the Motel 6 room while Johnson took Mercado Medrano to get more money. She was guarding the drugs at that point. She was waiting behind to guard the drugs and keep the customers company while Johnson went ahead and secured the larger $300 sale. Johnson and Mercado Medrano returned to the Motel 6 at 11:58 p.m. and they completed what Mr. Kennedy's been referring to as the second transaction. Well, at that time, 11:58 p.m. Is when Levi Connolly, one of the companions, posted a Snapchat photo. And that's the Snapchat photo that was presented to the jury that showed Mercado Medrano in front of a table with a handful of money and drugs on the table and defendant Stewart right there next to him. Now, the district court found that there was ample evidence by which a jury could just view this as one criminal act. And Your Honor, Judge Gregory pointed out that this was just minutes at best. That's correct. From the timestamps of the Motel 6 entries of the room, we know that the 2 different entries between the 2 rooms were about 53 minutes. So in all likelihood, the first distribution, if you call it that, and the second distribution were really only about 45 minutes apart from when that took place. And that is, Although the drugs may have technically been distributed twice, the law treats that as one criminal act. US v. Elliott states that multiple acts of physical delivery, which, although technically discrete, occur at essentially the same time in the same place and with the same participants, must be considered a single offense for purposes of punishment. And so I think either way you look at it, if you view it as one distribution, well, it's short in time. It involves all the same parties. Everybody was still there. It was at the same location. I think there's plenty of evidence by which a rational jury could find it was one distribution. But I think even so, even if you viewed it as two distributions, the evidence that I just rattled off a moment ago makes it pretty clear. She was in for a penny, in for a pound with both transactions, and they only happened about roughly 45 minutes apart from them. So the district court very clearly denied the motion for judgment of acquittal. I think that addresses all the issues that were raised in oral argument initially. I'd say that the United States stands upon all arguments set forth in its brief and ask this court to affirm the district court's rulings on all issues. And if there's any other questions at this point, I'd be more than happy to answer them.
All right, thank you, Mr. Hellman.
Thank you, Your Honors.
Mr. Moss?
Thank you, Your Honor. Your Honor, the government's failure to provide inquiry notice that possessed the cell phone, in conjunction with its failure to follow any established procedure, conduct any analysis of the evidence, or otherwise preserve it, amounts to bad faith and violation of due process that irreparably prejudiced the defendants. The convictions must be vacated. To rule in favor of the government would send a message not to affirmatively disclose the possession of evidence with apparent relevance, nor conduct any analysis of it, and to dispose of it prior to trial, and then hide behind the argument that the defendant cannot say what the evidence is to say whether or not it was exculpatory. It would undermine a fundamental premise of due process that a defendant can be convicted only upon competent evidence. And it would also open the door to future abuses of an important corollary principle to due process, which is that the defendant is entitled to be made aware of and to use all evidence. It would mean no check on the suppression and destruction of evidence because law enforcement agents would be able to defend the failure to disclose or the destruction of evidence by essentially violating with impunity the procedures that are in place that they're obligated to follow. And these are the very same procedures that exist to ensure a competent, credible, and transparent criminal investigation and prosecution takes place. As Mr. Kennedy said, to help ensure the public reputation and the integrity of the judicial proceeding, and make sure it's reliably free from bias or other forms of misconduct. But a ruling in favor of the government would again signal them that it is okay to ignore their own governing procedure or act inconsistently with it, and without fear of even the slightest repercussions. Mr. Johnson's conviction should be vacated. If somehow the court determines it is proper to affirm, Mr. Johnson's case should still be remanded for resentencing. His sentence was procedurally unreasonable because, as Your Honor pointed out, the district court erred by failing to address or explain why it rejected non-frivolous arguments. I don't think it was patently obvious why they rejected the departure, and I agree with the court that they never addressed the argument for variance. Both, of course, were based on the childhood lead paint poisoning, intellectual disability, and diminished capacity. I think that the record speaks for itself here, and it's insufficient to support a meaning appellate review on that issue. So the sentence was procedurally unreasonable. To just quickly, while I am a minute over, Your Honor, I will stand on the arguments of the brief. I'm happy to answer any other questions that the court has, but I would ask that Mr. Johnson's conviction be vacated. Thank you.
Thank you, Mr. Moss. Mr. Kennedy?
Thank you, Your Honor. Just really quickly, I wanted to first address United States v. Elliott, which was brought up by the government. in United States v. Elliott, one of the elements in order to find that they're a single offense is that they have to have the same participants. That was not the case here. In the first transaction, Johnson, Stewart, Madrano, BL, and Conley were the participants. However, in the second transaction, Johnson, Mercado, and Haynes were participants. So in both of the sales, there were people involved that weren't involved in the other sales. So that means that doesn't meet the United States v. Elliott test. And also addressing the acquittal argument again really quickly, all the activity that the government cited in its oral argument as being evidence of Stewart's participation was before the pause that we talked about, and the only evidence that the government cited in oral argument that she was involved in the second transaction was the Snapchat photo, which we would take the position that was mere presence. Also, I think it's important to note that Conley from the first transaction, but not the second, did not test positive for morphine, which I think again is an inconsistency in the government's case. And just really quickly again to hit the closing argument. I just want to cite for the court really quickly that what the science was that was testified to by the government's own expert is that heroin turns into morphine. Codeine also turns into morphine when they enter the human body, and that once they're in there, you can't tell where the morphine came from, whether it came from heroin, codeine, or something else. And so and that's what the defense was arguing. And by saying what the prosecutor said in the rebuttal, it undercut that argument, because not only did she say, no, that's not what happens, morphine turns into codeine. And also then she said that defense counsel, who had correctly stated the science, was wrong and misleading the jury. And so that goes to the but for cause element here. And so therefore it was a particularly egregious misstatement. And so unless the court has any further questions for me, I see I'm out of time. So I would stand on the arguments from our brief and also ask that Ms. Stewart's conviction be reversed. Thank you.
Thank you, counsel. We'll extend a virtual handshake to all of you and express our appreciation for your fine work today in your argument. Thank you so much. Wish you well, be safe, and stay well. Thank you.
Yep. Thank you, Your Honors.
All right.
Thank you, Your Honors.
Thank you so much. Would the panel like to take a break before we go?
Thank you and good morning. May it please the court, my name is Justin Harrison. It's my privilege to appear before you today on behalf of the appellate, Beckley Oncology Associate. There are two issues pending before the court this morning. One is whether the district court committed reversible error by confirming the underlying arbitration awards and refusing to vacate the arbitration awards in response to a Rule 12b6 motion. And the second issue is whether the parties entered into a waiver either in whole or in part regarding judicial review of an arbitration award. The answer to the first question is yes. The answer to the second question is no. Unless the court prefers otherwise, I'll address those issues in turn. This is the rule in the Fourth Circuit. When an arbitration award disregards or modifies unambiguous contract language, a federal court has no choice but to vacate that arbitration award. That's the holding in patent, which remains good law in this circuit. The arbitrator determined that the appellee, Dr. Abu Mazma, was entitled to receive incentive compensation for the third and final year of his employment at BOA. The arbitrator's decision disregards and modifies the plain and unambiguous language in the employment agreement. Direct your attention specifically to Section 5B of the agreement, which is included in our joint appendix at page 24. The sole and absolute discretion to award bonuses to Dr. Abu Mazma rested with BOA. There was a limited carve-out for the initial 2-year period of his employment, and that carve-out required BOA to pay Dr. Abu Mazma incentive compensation for the first and second year of his employment. BOA did that. BOA did not pay him incentive compensation for the third year, and that's what was arbitrated below.
Mr. Harrison, sorry, and I should have stopped you earlier, but I know you decided that you wanted to take these in the order that you just said, but it seems to me that the second issue might be dispositive, because if we were to find that the waiver in this case was enforceable, either in whole or in part, there'd be no issue to discuss with respect to the merits of the arbitrator's ruling. So can you talk about that first? And I want you to talk about it in the context of my understanding of the relevant law. So I think it logical to say that the FAA contemplates some level of review by a district court, because an arbitrator's award, for example, without confirming it, simply isn't enforceable. So at a minimum, it seems to me that a district court has a role to play in confirming an award, and perhaps corollary to that, the statute seems to contemplate a role for the district court in vacating or modifying an award. So the statute is clear as to that. So I would grant you that perhaps the waiver might not be enforceable with respect to that aspect of review. But why wouldn't it be enforceable with respect to the review before this court here today? I mean, there's nothing in the FAA that says that there is an express requirement of appellate review. And I want to analogize this to criminal cases. We enforce appellate waivers of criminal cases all the time. And even in cases where the waivers are too broad, we say, well, we're not going to enforce the waiver that's too broad, that might impinge on a defendant's right, for example, to allege ineffective assistance of counsel or prosecutorial misconduct. But we enforce those waivers in criminal cases, and it seems odd that we wouldn't do the same here. So talk to me about that. Why isn't this case simply resolved on the issue of you waived your rights to appellate review?
Thank you, Your Honor. The issue is going to turn in part on Section 16 of the arbitration agreement. That's where the waiver language between these parties is found. And so the issue before you is this: did the parties waive appellate rights to the arbitration award, or did the parties waive appellate rights to the district court's judge? And these parties rights to the district court's judgment. And as I'll explain to you, it's our position that the parties waived appellate review of the arbitration award based upon the plain language in Section 16. It did not waive appellate review of a decision regarding vacator confirmation. The closest case we have to treat this most is the Mac Tech case from the 10th Circuit. And I apologize to the panel. This case was not cited in our brief, but it was cited by the 9th Circuit in the Walmart case. And the 10th Circuit, and this was a decision that predates the Hall Street Associates case, 10th Circuit held that there's a distinction between a waiver that refers to an arbitration award and a waiver that refers to an actual court judgment. And so let's compare the language of the waiver provision in MACTEC 10th Circuit case. I apologize for reading it to you, but I want to be precise. In that case, judgment upon the award rendered by the arbitrator shall be final and non-appealable and may be entered in any court having jurisdiction thereof. That language contrasts with the waiver provision in Section 16 of the employment agreement between the parties in this case. The decision of such arbitrator shall be final and conclusive and enforceable in any court of competent jurisdiction without any right of judicial review or appeal. This distinction is subtle, but it's significant. The MACTEC case refers to a judgment. The provision in our case is referring to an arbitrator's decision. And according to the courts that have touched upon this issue, in order to have a waiver of judicial review or a waiver of appellate review, the waiver has to be clear and specific. And our argument here is that the waiver of judicial review in this instance, or excuse me, appellate review, is not sufficiently clear and specific to be enforced against the parties.
Mr. Harrison, sorry, Mr. Harrison. So how would appellate review occur in this case but for review of a district court's award? Because we would have no grounds to review an arbitration award directly, right?
Right, Your Honor. The language that comes from Section 16 of the agreement is a little bit stale. And frankly, it's been reviewed by several courts, and several courts have noted that that language simply refers to a waiver of any direct appellate review of an arbitration award. It does not refer to a waiver of appellate review of a district court's decision regarding vacater.
But I guess my question is, in what scenario would an appellate court ever review an appellate award directly?
I'm not sure there ever would be, Your Honor, but it might be a situation where the parties were trying to avoid appellate review by the district court of an arbitration award beyond those grounds that are set forth in the FAA or the court or the holdings of this jurisdiction. And so, just to be clear, judicial review is not a merits review of the appeal. It's a limited review based upon the statutory provisions in the FAA or manifest disregard standard, as this court has acknowledged and held in the past. And so
all right, so just so I understand your argument, it's that this clause might waive appellate review, direct appellate review by a court, even though that seems to be non-existent, but it's not clear enough that it intended to waive appellate review of a district court's decision as to whether to affirm, modify, or vacate. That's your position?
Yes, Your Honor.
Okay.
That's consistent with the holding from the 10th Circuit in MACTEC. I believe that's the only circuit that get that far on this issue. I will note that both the 9th Circuit and the 3rd Circuit touched upon it. They have declined to reach that issue because those cases were resolved on other grounds. One is the South Coke case out of the 3rd Circuit. The second one is the Walmart case out of the 9th Circuit. But to the extent that this court finds the holding in MACTEC to be persuasive and wants to follow it, we fall outside of it. Because here, unlike in MACTEC, we're only talking about appellate waiver of an arbitration award rather than appellate waiver of a judicial decision from a court. And so I think that distinction is relevant with the goals and the purpose of the FAA. If the court, I'm sure the court's familiar with the holding, but Justice Souter noted in Hall Street Associates that the provisions of the FAA were unique. Federal courts are required to confirm an arbitration award unless the award is vacated, modified, or corrected as provided in Section 10 and Section 11 of the FAA. And because of this, parties are not for arbitration awards, and any provision that interferes with that process is unenforceable. I think that language applies to general waivers of judicial review. I think that language provides some color as to how the court should proceed in evaluating any appellate review of judicial review.
Okay, so let me ask you about Patton, because you mentioned that case, but isn't the distinction in Patton that the arbitrator in that case attempted to incorporate language from an entirely different agreement into the one that he or she, I don't know if it was he or she, was considering? And doesn't that make a difference here? Because the arbitrator in this case is fixed solely on the agreement before him. And as you know, I mean, our cases are pretty clear that the only thing an arbitrator needs to do is to do his or her job, whether he or she does it well or commits an error of law. That by itself isn't enough. So why is patent at all relevant in this context?
I think patent controls, Your Honor. You're correct. The arbitrator's mistake, the arbitrator's disregard of the law and patent came down to this. He was required to evaluate the choice of law provision in the agreement, which referred to Massachusetts law. Massachusetts law provided for a longer time limitations period. The arbitrator didn't look to Massachusetts law. Instead, he borrowed a time limitations period from an agreement that was no longer effective. And by doing that, he went beyond the four corners of the contract. He ignored the plain and unambiguous language of the contract. And by doing that, he modified it, right? That's exactly what happened here. Disregarded the plain terms because he ignored West Virginia law. And West Virginia law in this instance provides that you cannot have an equitable remedy of unjust enrichment in the face of a valid contract that covers the same subject. We have that here. Section 5B delineates the parties' rights and obligations with respect to the issue regarding the incentive compensation for the third year. During the third year of employment, the sole and absolute discretion to award bonuses rested with BOA. The arbitrator ignored that. The arbitrator ignored that by going out and doing his own research to find out what fair market value was to pay Dr. Abu Mazma. By doing that, we're running afoul of the holding and patent in terms of manifest disregard. By doing that, it's going to draw a test of agreement because the arbitrator is worried about how fairly Dr. Abu Mazma is being treated. The contract didn't require fair market value. The contract didn't require that he be paid fairly. The contract specifically stated, here's your base compensation, $275. During the first 2 years of employment, here's your incentive compensation piece. Beyond the first 2 years, the sole and absolute discretion to award bonuses rests with BOA. So when I look at it that way, Your Honor, I think patent's directly on point. And I know we're supposed to be deferential to arbitrators. I know the scope of review for reviewing an arbitration award is deferential, but I would submit to you that this is the rare case where you have an arbitrator that went rogue, went outside the contract, tried to figure out a remedy that no party saw. You know, keep in mind that Dr.
Well, I thought the district court in this case, Mr. Harrison, I thought the district court in this case concluded that the employment agreement, that the arbitrator had found that the employment agreement provided for a bonus, but it didn't provide for the mechanism for calculating that bonus. And therefore, again, I forget if it was a he or she, devised a method as a matter of equity to arrive at that amount. And the court said that, in fact, the arbitrator had equitable powers to do so. So I guess you disagree with that first premise, but doesn't the agreement suggest, I mean, it does say employer has a sole and absolute discretion to award bonuses, but then it sets out a mechanism for bonuses during the first 2 years. And then at the very end of that clause, it says that future bonuses will be subject to renegotiation between the parties. That seems to contemplate that there was supposed to be a bonus of some kind, but that the formula was just never arrived at by the parties. Looks like he's frozen. Oh, he's gone.
Mike,
I overwhelmed him. I don't know if you caught that question, Mr. Harrison, but did you catch the tail end of the question?
Your Honor, at the beginning of the question, you asked me about Judge Berger's decision.
Right, and then after that, I talked about the language of the agreement itself, which, as you accurately pointed out, that it begins with a statement that whether or not to award a bonus lies in the sole and absolute discretion of the employer, but then it sets out the bonus structure for the first 2 years. And then the last sentence says that, I don't have it in front of me right now, but that future bonuses will be subject to renegotiation between the parties. And so the district court seemed to think that based on that language, that there was a clear agreement among the parties that there was going to be an amount of a bonus beyond the first 2 years, but the mechanism for calculating it hadn't been established. And so the arbitrator was within his rights to do that. Now, that may be wrong, but how is that a manifest disregard of the law?
Your Honor, in order to support, you're correct about the district court's analysis, and it's illustrated in footnote 2 of the opinion, but it's also speculation. And the district court, frankly, is speculating as to whether the arbitrator determined that provision to be ambiguous. My position is this: regardless of whether that speculation is correct, and regardless of whether the arbitrator determined that provision to be ambiguous, it's not. And the clear and unambiguous, that's not an obligation to award a bonus. That's an agreement to agree at a future date. In fact, it's not even an agreement to agree. We've cited cases from around the country in our briefing. That is permissive language. It does not obligate a party to do anything.
But it does indicate some intent of the parties going forward after the first 2-year period to negotiate something. And you do have one side, the doctor did perform, didn't he, the 3rd year?
Yes, sir. He worked the 3rd year and he was paid his base compensation as the contract required. But he was told, I'm sorry, go ahead.
Is there anything in this contract that would suggest that your client would have allowed him to work without and generating what would be a bonus amount without negotiating in good faith some compensation?
Your Honor, I would refer you to Section 23 of the agreement, which simply requires the parties, if they're going to modify the agreement, it has to be in writing and signed by the parties. That never happened.
But doesn't the contract talk about equitable remedies are available for the arbitrator to consider?
Consistent, yes, Your Honor, consistent with West Virginia law.
Well, wouldn't that be consistent with, for example, quantum merit?
No, Your Honor. If we have a contract in place that is providing compensation to an employee under West Virginia law, you do not get an equitable remedy regarding restitution or unjust enrichment. And in fact, our Supreme Court recently reaffirmed this.
But you didn't have a contract. You didn't have a contract in place other than orally that you would, in good faith, negotiate if he worked for you the 3rd year.
Your Honor, there was no requirement.
Wait a minute. Am I wrong about that?
I think so, Your Honor, because the contract doesn't require negotiations.
I didn't say require. It says you express your intent. Your client had an intent to, in good faith, negotiate a bonus structure if he worked in the 3rd year. Is that correct?
I disagree, Your Honor.
Which part is this? What they didn't, in good faith, they didn't intend to do that?
I don't think the contract requires that, Your Honor.
I didn't say that. I'm not asking you that. I'm asking about your client. Are you saying that representing that your client had no intent to, in good faith, negotiate if he worked in the 3rd year?
Your Honor, here, let me answer it this way. I'm not trying to duck your question.
Well, you're doing a good job of it.
Well, the contract was set up at a 2-year mark because that's when Dr. Abu Mazma became eligible for partnership. Now, he chose that opportunity was afforded to him, and he backed off because he realized he was going to get paid less than had he stayed an employee under the original structure of his contract. Okay, so that was the intent. This is a doctor coming in. You know, it's a recruitment tool. It's negotiated at arm's length. He comes in, does 2 years. At the end of 2 years, he makes partner. Well, he decided he didn't want to make partner, and so he's operating under the 3rd term of the agreement. The 3rd year term, does not require payment of incentive compensation bonuses. It doesn't even require negotiation. It's omitting a significant word, which is shall. And I've seen executive employment contracts and their court decisions which talk about parties' obligations to engage in negotiations if the word shall is in there. But we don't have shall, we have subject to, which is permissive language. It does not require negotiation. It does not require an agreement. And so our position that arbitrators—
So, Mr. Harrison, can I ask, okay, so that's a reasonable interpretation, I get that. But what if the arbitrator interpreted that subject to renegotiation as shall? That may be an error of law, but how is it a manifest disregard of the law?
Your Honor, because it ignores the plain language of the contract. And I realize that we're talking about—
No, I think the arbitrator is trying to interpret the contract, and you have a view of the contract. He came up with a different view of the contract. Yours may be the better view, and his may be wrong, but how is it manifestly wrong? I mean, that's a pretty high bar.
I think it's manifestly wrong to the same extent that the arbitrator got it wrong in Patton, Your Honor.
You know, it's your client who probably asked for arbitration, didn't he?
No, sir.
It's not? The arbitration agreement wasn't generated by your client?
I'm sorry, Your Honor. I thought you were referring to the demand for arbitration. The arbitration.
No, I'm coming to demand. It starts with an agreement. What didn't your client want an arbitration clause?
Your Honor, we don't have well-developed evidence on what the parties wanted with respect to the arbitration clause. I can tell you, the record's not before the court, but I can tell you that the agreement was borrowed from an older template that was prepared 20 plus years ago.
And I've seen very few that wasn't generated by the employer.
I have no reason to believe that Dr. Abu Mazma requested the arbitration provision.
Right, okay.
So, you know, I understand, Judge Diaz, your concern about where we draw the line on vacator. And, you know, I think I think what happened here fits squarely within Patton. You've got an arbitrator ignoring the plain language of the agreement. And, you know, at some point there has to be a judgment call made by a court, the district court, this panel, as to whether the arbitrator did that. We submit based upon the plain language of the agreement, he did that. I see that I am over my time, and I will reserve any additional comments for rebuttal.
Thank you so much, Mr. Harrison. Mr. Ahmad.
Thank you, Your Honors. May it please the court. My name is Omar Ahmad. I represent Dr. Abu Mazma. And as an initial matter, to touch on Judge Diaz's point, I agree, Your Honor. I believe that the issue of the non-appealability provision is dispositive in this matter. And all of the case law set forth by BOA in support of that not being applicable here was limited to a district court's ability to confirm or vacate award consistent with the FAA. It doesn't stand to reason that a party would draft a non-appealability provision, not to enforce it. This was clearly limited, and we'll grant that. You know, the district court has to retain some level of review in order to determine whether or not the award comply with the FAA. But beyond that, there was clearly an intention by the parties to preserve whatever the arbitrator ruled upon and whatever the district court either confirmed or vacated. There's no clear argument here that the parties agreed to a provision that couldn't be enforced. So in that respect, I don't agree that the non-appealability provision is not applicable in this case. And I also want to touch upon this court's holding in McKenzie, as it's followed in every other court in interpreting contract terms. Ambiguity in a contract goes against the drafter. So if it's the BOA's position that, you know, it wasn't clearly lined out whether or not appeal prohibition applied to the district court's confirmation or vacator or any review beyond that, I would argue that it goes against BOA in that sense, and that any appeal beyond what was necessary to confirm or vacate the award should be foreclosed in that sense. Also, Your Honors, to touch upon, even if we do want to get to the issue of whether or not there was a manifest disregard of the law in this case, I would argue that there wasn't. As the arbitrator pointed out and Judge Berger confirmed, Section 5B does set forth that there is sole and absolute discretion by BOA to declare and award bonuses. But as Judge Diaz pointed on, at the end of the section, it indicates that the subject terms are only applicable for the first 2 years, the initial term of the agreement, and are subject to renegotiation in subsequent renewals. That clearly manifests the party's intention that this bonus would survive the initial term, subject to the terms of the agreement. Once BOA put pen to paper in declaring the bonus in the agreement, they were required to abide by that bonus, ending that bonus, etc. There was no written modification removing the bonus as required by Section 23. And at the end of the second year, the initial term of the agreement, the automatic renewal provision automatically extended all the terms of the agreement as they were absent of written.
Mr. Ahmad, can I ask, so if this case had not been arbitrated and instead litigated in court, what's the rule of law that you say that would result in a verdict for your client? I mean, this seems to me like what you've got here is an agreement to agree without the essential terms of how to go about arriving at what the precise amount of the bonus would have been in the third year. So what, do you think that you would have prevailed in a court of law on this claim, or is it just too indefinite to be enforceable?
I believe we would have, Judge. I believe that you kind of touched on this a little bit. The renewal provision maintains the agreement as it stands, absent of written modification. So, by the parties carving out an exception in Section 5B by placing the term subject to renegotiation, there was clearly an intent by both of them to allow this bonus to survive the initial term. That language was included there in the event that Dr. Abamasma didn't work past the initial term of the agreement. So I believe a jury would look at the intent of the parties in that you were trying to establish these terms as they see them on day one of employment, that there is an opportunity for Dr. Abamasma to earn bonus compensation beyond the initial term, but there's no requirement that the parties renegotiate the terms of the contract. Again, as you can see from Dr. Abamasma's production in his third year, he was clearly operating on the understanding that there was bonus compensation because there was no written modification, either removing the bonus provision or modifying the terms. So I believe.
But the arbitrator in this case, and part of it, I understand what part of the reason why he did this, apparently he didn't get much help from the parties, is he came up with a formula which he, I guess, equated to some sort of rough justice in terms of what a bonus should be. But do you think that would have won the day in a court of law, that a jury could have just out of thin air come up with a bonus amount and said, that's what your client is entitled to?
Well, with all due respect, Your Honor, I don't believe Arbitrator Snyder necessarily pulled this remedy out of thin air. He equated it to the mechanism the parties used in the initial term, which was a percentage of gross receipt. And using that, the spirit of that formula, the whole intent behind it was to provide Dr. Abamasma with a percentage of gross collections. He awarded half of 5% of the part of the gross collections that yielded a 2 to 3% margin. That is in keeping with the spirit. More collections Dr. Abamasma brings in, a higher percentage of those collections he's entitled to.
I'm having trouble hearing you. Can you get a little closer to your mic?
My apologies, Judge. Is that better?
That's better.
As I was saying, Judge, I believe a jury could, based on the evidence in this case, infer the party's intention that in a bonus clause that indicates that it's subject to renegotiation in further incantations of this agreement, there was intent to either preserve the nature of giving Dr. Abamasma a percentage of gross collections, or following some other mechanism if the parties provided a written modification thereto, setting forth that mechanism. So the fact that the arbitrator awarded if I believe I'm reciting his wording correctly, 1/2 of the 5% above the 95% that constituted the chemotherapy drugs, then that is in keeping with what the parties intended. The more collections, the more bonus. Well, Dr. Abamasma, he reached a certain point here where he was entitled to bonus compensation, but as Arbitrator Snyder pointed out and Judge Berger affirmed, the agreement erroneously leaves out a procedure for the parties to reach that agreement. That, by definition, is ambiguity. It was subject to two different interpretations, one by BOA, which they've set forth, and one by Dr. Abamasma, which was clearly set forth in his conduct during the third year. And I also like to point out here, Judge, at no point during the third year when Dr. Abamasma inquired as to what when he'd be paid his third year bonus, did BOA outright inform him there was no bonus. If you recall from our brief, there was a shareholder meeting the month before Dr. Abamasma left the practice in which he posed that question to the shareholders. And their response to him was, these agreements will be rewritten based on the restructuring of the corporation, and that we are going to most likely utilize what's called the WRVU methodology, which is basically, and I'm straying from the point here, Judge, it's a unit-based measure of production to determine compensation. My point is, judges, during the third year, there was nothing by the terms of the agreement that BOA did that would foreclose a bonus provision to Dr. Abamasma. That's why he worked to increase his collections more than any other shareholder there. And Arbitrator Snyder correctly viewed that fact, that the ambiguity in Section 5 is construed against BOA, and the conduct of the parties here clearly evidences an intent to give Dr. Abramovsky bonus compensation beyond the initial term. The only problem is there was no mechanism to decide it. And again, that ambiguity must go against BOA. And Your Honor, if I believe I've answered your question sufficiently. If I haven't, let me know. But I'd like to touch upon, even if this court doesn't find that issue, the issue of the non-appealability dispositive, I would like to touch on the matter of the manifest disregard of law claim as BOA has raised it. Again, Your Honor, as Judge Diaz pointed out, this was not a manifest disregard of the law. And I'd like to remind this court of its role in assessing an arbitration award. As Judge King pointed out in Data Quick Info Systems opinion, the scope of judicial review for an arbitrator's decision is among the narrowest known at law. And I'm paraphrasing here because I don't want to read the whole holding, but in reviewing such an award, a district or appellate court is limited to determine whether the arbitrators did the job they were told to do, not whether they did it well or correctly or reasonably, or simply whether they did it. And I believe Judge Gregory, it was you that pointed out in Section 16, the agreement gives the arbitrator the right to apply, the right and duty to apply legal and equitable relief. In this instance, he was not dealing with unambiguous contract terms where he could just simply try to, advance the will of the parties. These were ambiguous terms that not only conflicted with the language within Section 5B, but they also conflicted with the requirement that any change to the terms be subject to writing signed by the parties. It conflicted with the automatic renewal provision that preserves all of the terms as they are after the initial term is complete. And in the face of that ambiguity, Arbitrator Snyder applied an equitable remedy based on the conduct of the parties. Nobody stopped Dr. Abu Masma from out-earning the shareholders in year 3 because they knew if they did that he would lose all incentive to increase his collections. And in that sense, that is not dealing in good faith with Dr. Abu Masma.
I think you paraphrased the sort of the very deferential standard that we apply in this case, but I think you would agree that an arbitrator can do a job so badly and so irrationally that a court would have to step in, I guess. But your point is that this is not that case, that given the ambiguity in the agreements, that the arbitrator did his level best to come to a result that equated with the intent of the parties. And even if he was wrong on that point, we can't say as a matter of law that he manifestly disregarded the law. Is that right?
I think that you said it better than I even could, Judge Diaz. Yes, this is not, as I said, a standard that is one of the narrowest known at law requires a departure from the law so egregious that it's plain on its face. The fact that the arbitrator was trying to interpret a bonus provision that was poorly written is not a manifest disregard of the law. He wasn't, as you pointed out, in patent borrowing provisions from other agreements or making up his own provisions. He applied a methodology that these parties agreed to for the initial term of the agreement, which was a percentage of collections with the bonus of Dr. Abu Masma in his award. And I'd like to point out, his award was less than half of what Dr. Abu Masma would have received had we applied the calculation method from the initial term of the agreement. So in that respect, it's hard to argue that he reached a decision that was manifestly unfair.
You're breaking up a little bit for me now. Get closer to the mic or something.
My apologies, Judge King. In that respect, it can't be argued that that was a manifest departure from the law in this. The law in every case that BOA set forth, and we put this in our brief, requires the arbitrator to interpret the party's intentions in the we made it not plain and unambiguous language. And in fact, in Judge Berger's decision granting our motion to dismiss the complaint to vacate the award, she dispensed of that in 2 sentences. She said that BOA misstated arbitrator Snyder's ruling. This was not plain and unambiguous language. A bonus provision that sets forth the mechanism for calculating it the first 2 years indicates those terms are subject to renegotiation in subsequent terms, and then provides no mechanism for the parties to reach that mechanism is ambiguous, and in this case must be construed against BOA's interests. I fail to see how that's a manifest disregard of the law. And in every case that was cited by BOA, it dealt with conduct that is not present in this case, borrowing provisions from other agreements, arbitrators who are either biased or in favor of that was not present here, Your Honor. And it's just, quite frankly, this is BOA trying to change the rules of the game after it's over because they lost. That's all it is. It's how can you argue a non-appealability provision that upholds the purpose of submitting this dispute to binding and compulsory arbitration is not enforceable? That's a laughable argument, Your Honor. Beyond what the district court has to do to ensure that an award complies with FAA and either vacate or confirm, that provision holds steady. That's the whole point of this, is to avoid, with all due respect, I enjoy being here in front of you all today, but that provision and the point of arbitration is to avoid situations like this. If Dr. Abu-Masma knew that that provision was meaningless, he would have simply submitted this in state court and let a jury sort it out. That would have been more advantageous to him than submitting the binding arbitration. It's an after-the-fact denial of Dr. Abu-Masma's right to access the courts for this dispute. And that was not a provision he drafted. That was BOA's provision. Your Honor, I fail to see how there's any manifest disregard of the law in this sense. And to touch on another common law ground under which awards may be vacated, this award also drew its essence from the agreement. If I may cite the court's holding and make sure I'm getting the case name here correct, my apologies. In the Richmond newspaper case that was authored by Judge Traxler, an arbitration award does not fail to draw its essence from the contract where it provides a plausible reading of the agreement. A plausible reading of the agreement as it was drafted was to incentivize Dr. Abu-Masma to increase the collections of BOA, and he did that outstandingly. The reason, and to touch on what BOA pointed out, that the arbitrator was concerned with the fairness of Dr. Abu-Masma, he brought up Dr. Abu-Masma's collections to point out the fact that he was holding up his end of the bargain, that he was increasing collections to BOA in his third year because there was no conduct, no written modification, removing the bonus provision, altering its terms, it automatically triggered the automatic renewal, preserved the bonus term as it was. And so if it was the essence of this agreement was to reward Dr. Abu-Masma for increased collections to the practice. I fail to see how an award that applies a similar methodology by taking a percentage of those collections, even a percentage that was lower than what Dr. Abu-Masma should have received if we just extend the initial calculation method, how that does not draw its essence from the agreement. So, Your Honor, I believe that the only option here, I see that I have 3 minutes left. I believe that we've touched on every point that's relevant here. The non-appealability provision is dispositive in this case, Your Honors. You cannot allow BOA, with the provision that it drafted, come before the court and tell you that they never intended to enforce that provision. That's unconscionable. That was never the party's intention. Dr. Abu-Masma signed away his right to access the courts, and you shouldn't allow BOA to circumvent that agreement now because they're not happy with the outcome. We ask respectfully, Your Honors, please, we ask that you please affirm this award in keeping with this circuit court's very, very high standard for overturning these awards. None of those factors that are required to do so are present in this case. And I'll be happy to take any questions you have with the remaining time I have left.
All right. Thank you, Mr. Ahmad. Mr. Harrison, you have some time reserved.
Thank you, Your Honor. Briefly, I would like to revisit the non-appealability issue. Just a couple of points. Dr. Abu-Masma has not cited any authority that allowed for waiver of appellate review, given the language that the party used in Section 16 of the employment agreement. And just to reiterate that point, coming from the 10th Circuit, we believe that language is not enforceable to waive appellate review of a district court's decision regarding vacator confirmation. I want to return to the merits of vacator. First of all, this issue of ambiguity is kind of interesting. Ambiguity is a question of law. And prior to receiving the awards in this case, it was the appellee's position throughout the entire arbitration proceeding that the plain and unambiguous language of the contract provided him with incentive compensation based upon the same methodology that was used during the initial term of employment. It wasn't until the arbitrator issued his award that the appellee adopted the position that the subject to language is plain is ambiguous and should be construed against BOA. But let me address that for a second. At page 24 of our opening brief, we cite a litany of cases specifically addressing that subject to language and how it's permissive rather than mandatory. The appellee has not cited any language from any court that disputes the authority that we have provided you. We do not believe a plausible reading of that agreement is ambiguous or requires BOA to engage in renegotiations and provide Dr. Abu Mazma an incentive bonus for the third year of his employment. During my opening remarks, I did not get the opportunity to touch upon the other two grounds for vacator. I would like to briefly touch upon those now, if I may. There are two additional grounds for vacator that we have asserted, and admittedly, there is some overlap factually with how they're supported. The second common law ground that's been recognized by this circuit is whether the awards fail to draw their essence from the agreement. We obviously believe they don't. And as this court held in Patton, in terms of that concept, a federal court must vacate an arbitration award if the award is based upon the arbitrator's personal notions of right and wrong. The language in the awards clearly indicates that the arbitrator was concerned that Dr. Abu Mazma was underpaid. He referred to the doctor's astonishing efforts. That's a quote. His extraordinary revenue. That's a quote. It's clear that he thought it was unfair to limit him to his base salary, $275,000. And in support of that, he even conducted his own research. He went out and pulled market surveys to find out what oncologists make somewhere around here somewhere. He didn't really specify where. But he did note that he thought his award was quote unquote fair or reasonable value for quote unquote a hardworking oncologist. And so when you take that language from the arbitration awards, it's pretty clear that the arbitrator was substituting his notions, his personal notions of right and wrong. We think vacator is warranted based upon that, because those agreements based upon his own personal notions, based upon the arbitrator's personal notions, fail to draw their essence from the agreement. The third ground for vacator that we asserted at the district court level was section 10A4 under the FAA. That rule provides that an arbitrator exceeds his powers under section 10 when he reforms the material terms of the contract so that the agreement conforms to his own sense of equity and justice. I think that concept is fairly similar to the failure to draw essence from the agreement type of analysis, but we have cited some case law in our briefing, which we believe supports vacator in that context as well. Specifically, I would like to refer the court to the PMA Capital case. Factually, that's a unique case. It was a three arbitrator panel trying to resolve an insurance dispute. Arbitration provision in that agreement, something called an honorable engagement clause, which is pretty unique. And that affords the arbitrators extraordinary discretion to fashion a remedy to accomplish the party's goal. The arbitration panel in that case eliminated a provision of the contract. On appeal to the Third Circuit appealed the district court's vacator of that award under section 10A4 because the arbitrators were not empowered to do that. We have that here.
Let me ask you a question.
Yes, sir.
Why? And I understand your argument, but the question is, why did you put in a term saying that the arbitrator can consider equitable consideration, can consider equitable standards or doctrines or whatever you might call this? Because it seemed to be now you're arguing in contrary, because if you're right, then you're wrong to put equitable in, correct? Doesn't that make it ambiguous? Because you're saying it either is agreement or if it's not. Here it was not, you can't go any further. So what would be the need to have the duty to have equitable remedies if that's how it should be interpreted as in a whole? Tell me, can you explain that?
Yes, Your Honor. If you look at the arbitration agreement in the parties' contract, it's extraordinarily broad. It covers a whole host of possible situations or issues that may develop between the parties. It's much broader than any dispute that could exist simply based upon the contract itself. And so I didn't draft the agreement. I didn't draft the provision. I wasn't involved in negotiating it. But I can tell you that it's all encompassing.
But the agreement belongs to your client, right? I mean, you wrote it up. Your client did.
It belongs to both parties, Your Honor, correct.
Well, but
my point would be this, Your Honor, even if the agreement allows for the arbitrator to rule upon a claim for equitable relief, it still has to be consistent with West Virginia law. That didn't happen here. The claim for equitable relief still has to be appropriate under the facts and circumstances of the claim. We have a contract. The contract specifies the doctor's compensation. It's quite clear as to what the doctor's compensation is supposed to be. So going back and tinkering with the doctor's compensation through an equitable remedy would not be appropriate.
Well, that's if the contract clearly said there's a clear intent not to give him any more than his base salary. That's not the case. You said, and you're right, you don't know the terms of it, but you opened the door in the very document. After the second year, this, meaning the bonus structure, is subject to negotiation. There's no indication that this was the end and that you wouldn't do that. And just like you just said, it's no way to clearly cover everything. That was your answer to why you said equitable type terms can be used. Isn't this one of them? There's no way to figure what to do when, for example, your client decided not to, again, you opened this up. You said that he decided not to be a partner, right?
Right.
And then you, this is your word, I heard very carefully, you said, well, this was just a tool that would be used from partner. Then after that's sort of the great divide, then we determine what's on the other side of that. Did you say that?
I didn't use those, those words, but that's the gist of it, correct?
It's the gist of it, right? So,
yes.
so then in that, when you look at the whole context, because you wanted the arbitrator to do it, you know, no offense, you didn't want judges to do it. You wanted an arbitrator to do it. Now you want to come to the district court judge. Now you want to come to us too. But isn't that the kind of thing that comes up when you put in is subject to? You didn't, when he said he didn't want to be a partner, did you say base salary only?
Your Honor, there's record evidence in the case. I don't know if it's before the court in the JA, but Dr. Abu Mazma was told at the beginning of the third year the bonus terms would be changing.
Right, but that's the same thing as renegotiation. That's not saying you will not get a bonus.
I don't think the contract requires that, Your Honor. We're kind of getting into this promissory estoppel analysis that I don't think is applicable. We have a contract that's on point. I'll grant you this, Judge. If you think that subject to language is ambiguous, then I lose. Right? I'm acknowledging that. I don't think that subject to language is ambiguous. And I just don't. We have case law supporting our position.
And you think if we ruled that it is, we are wrong, right?
I do.
Just like you do for the arbitrator. You think it's wrong, right?
Yes, Your Honor. I have strong opinions.
And that's not the standard for overcoming the arbitration's award.
Well, I think he's more than wrong, Your Honor. I think he's exhibited manifest disregard. If I might, just recently, Your Honor, back in 2012, I think this is reiterated. This is the standard, the two-part standard for manifest disregard in this circuit. You have to have an applicable legal principle that's clearly defined and not subject to reasonable debate. The arbitrator refused to heed that principle. I do not believe that subject to language is subject to reasonable debate, even though the parties may not agree to it, because ambiguity is a question of law. It's not a question for the parties to agree or disagree about. And based upon the case law we've cited to the court, subject to is simply not ambiguous. I realize you may disagree at the end of the day, Your Honor, but I just want to make sure my point was clear.
I just want to make sure that he says it's not a factual question, it's a question of law, right?
Yes, Your Honor.
And who did you decide to give that right to make those decisions of law?
That was the arbitrator.
Okay.
I see that my time is over. If any,
I think Judge King, did you have a question?
No, I'm fine.
Okay,
thank
good.
you.
All right. Thank you so much, Mr. Harrison. And thank you both for your arguments, and we'll extend a virtual handshake to you as well. And thank you so much for your argument here today, and hope that you will be safe and stay well. Thank you so much.
Thank you, Your Honor.
Thank you, Your Honors. Have a good day.
Thank you. Same to you. All right, we'll proceed to our final case for Ms. Costner.
Good afternoon, Your Honors. May it please the court. My name is Lisa Costner, and I'm here today representing the appellant Bobby John Cabito. In 2019, Mr. Cabito was charged with and pled guilty to possession of an unregistered firearm, specifically a homemade silencer. In the pre-sentence report, the terrorism enhancement was applied pursuant to 3A 1.4 of the sentencing guidelines, which increased Mr. Cabito's advisory guideline range from a base offense level of 18 to 30 and his criminal history category from 1 to 6. The pre-sentence report also applied a 4-level increase for possession of the silencer in connection with another felony offense. The pre-sentence report, the felony offense that the pre-sentence report stated was felony terroristic threats. That enhancement was pursuant to 2K 2.1B6B of the sentencing guidelines. Mr. Cabito objected to both of those enhancements, and both were overruled by the district court. The court at sentence.
Now your client entered a guilty plea, right?
That's correct, Your Honor. He did.
And he doesn't challenge the guilty plea.
Your Honor, and I'm sorry, Your Honor.
He doesn't challenge the guilty plea. He challenges these two enhancements. That's right.
That's correct, Your Honor. I did not represent Mr. Cabito in the lower court, but there was no motion filed to set aside that guilty plea that I saw on the record and no hearing. So he proceeded forward to sentencing after pleading guilty.
That's right. There's no issue about the validity of the guilty plea. The only issue is sentencing, and he challenges how Judge Tilley handled these two enhancements.
Yes, Your Honor, that is correct.
And then the final analysis, Judge Tilley gave him, 5 years?
That is correct. He faced a statutory maximum of 120 months. Judge Tilley did vary downward and sentenced him to 6 months at active time.
Right, he could have got 10 years.
Yes, Your Honor, that is correct. He could have.
And the terrorism incident would have been an attack on the Terry Sanford Courthouse in Raleigh.
Yes, Your Honor. The government, what the government said at sentencing was that the silencer was committed. Possession of the silencer was committed to further a violation of 18 U.S. Code 1363, which was attempt or conspiracy to injure or destroy property within the special maritime and territorial jurisdiction of the United States, and that was the Terry Sanford Federal Building in Raleigh.
Okay, go ahead. I'm sorry. I just want to get that background in here.
Thank you, Your Honor. Your Honors, this terrorism enhancement has a huge impact on a defendant's sentence. Had it not been applied to Mr. Cabito, his advisory guideline range would have been 18. Of course, he would have gotten a 3-level deduction for acceptance of responsibility. And without the 4-level increase for possessing the silencer in connection with another felony, his criminal history category would have been 1, and his advisory range would have been 18 to 24 months, a pretty significant decrease from the statutory maximum that he faced of 120 months. 3.4, the sentencing guideline, I'm sorry, I thought I heard a question. Provides that if
you're fading out some for me, Ms. Cosner. Can you get closer to the mic or something?
Yes, I'll try my best. Is this better?
It's better.
Okay. So if the offense is a felony that involved or was intended to promote a federal crime of terrorism, That's when the guideline score is increased 12 levels or to a level 32, whichever is higher. And then the criminal history category of the defendant goes automatically to level 6. We can find the definition for federal crime of terrorism by referring to 18 U.S. Code 2332 BG5. And what that says is that a federal crime of terrorism must be an offense that is calculated to influence or affect the conduct of government by intimidation or coercion, or to retaliate against government conduct, and is a violation of the certain enumerated statutes. And at sentencing, as I said before, the government contended that that statute was 18 U.S. Code 1363. In our brief, we raised several issues with respect to whether that the terrorism enhancement should have been applied. And we argued that, first of all, Mr. Cabito could not have been convicted of an attempt to of conspiracy to violate 18 U.S. Code 1363. The only possible co-conspirator would have been the undercover government agent. And as this court has held, a government agent participating in a sting operation is not a co-conspirator. That Mr. Cabito could not have been convicted of attempt to violate 18 U.S. Code 1363, that there's just, the government couldn't prove or not sufficiently that what Mr. Cabito did was to take substantial steps towards completion of the crime. Mr. Cabito certainly engaged in a lot of phone conversation talking about the crime and what he, his thoughts about it, but there's no evidence that he took any substantial steps towards completion of the crime. And I would say that what his conversation sounded like was more along the lines of trying to impress this undercover agent. If you look at, go ahead, Judge King, did you have a question?
No, listen.
No, ma'am. Go ahead.
Sorry, they light up sometimes.
The silencer.
The possession of the silencer?
Yeah.
Well, certainly in his conversations, he discusses the silencer and what he would do with the silencer. But as far as the rest of the conversations, Judge Gregory, he talks about, there's never any conversation about a specific plan, a day, a time, how he's going to get there.
Do you need that? Do you need that as an act in furtherance?
Well, I would say that he at least there at least needs to be some evidence that goes beyond just the possession of this silencer, that to show that he in fact had the intent to commit this act.
He was trying to encourage people to do it, wasn't he?
I would disagree. I think he's talking to the agent. He does say something along the lines of, it would be better to have two people but they never go so far as to actually put together a real plan to do this. And he never really.
You're not citing the law. The law doesn't have to be a precise plan. I mean, he did more than just possess the silencer, right? That was in conjunction with shooting at the buildings, wasn't that? And a silencer would be easier to perfect that, right?
He did talk about that.
And you're saying that's not enough? Here, we're not. This is not an indictment. This is an enhancement that only has to be proven by preponderance of the evidence.
I'm sorry.
Right? Correct?
Yes, preponderance of the evidence. That's exactly correct. But I would characterize a lot of what he said is hyperbole. I mean, he's bragging, boasting, but he's doing very little.
That's your spin on it. And if it was a trial, maybe you would convince the jury it was. But is that the standard for an enhancement? I mean, my goodness, we enhance people's standard, and the people not even in the courtroom at all, and they talk about the quantities of drug you sold, and people never even come to court. And now you're saying for this case, we have to have a full-blown, would be close to a trial with jury instructions and everything you're talking about, because now you said it was just blustering, it was hyperbole, he didn't really mean this. I mean, I understand you're his counsel, you're doing a good job for his side, but is that enough to take this out of a crime that involved an act of terrorism for an enhancement?
Well, I think when you look at what he did say and what he didn't say and contrast that. So, you know, he talks about, he sends a Google map, for example, to this agent. Well, anybody could go and you know, search Google map and do that. He
act in furtherance, isn't it?
I mean, if a Google map, I would say.
Anybody can send the address of the bank you're going to rob. We use those as act in furtherance. Rent the car, put gas in it, make arrangements. Those are acts in furtherance. We do it all the time. I mean, it's nothing special about this case that now all of a sudden, oh my goodness, we can't look at these things. How so?
Well, I would argue that what he was doing was engaging in a lot of talk, and he was bragging and trying to make.
But he pled guilty, Ms. Costner. He pled guilty to all this. He pled guilty, and Judge Tilley reviewed the facts and found by preponderance of the evidence that both these enhancements applied, and then he cut him a break. He reduced the sentence by 50%. He cut him a break. He got a sentencing break, a very substantial sentencing break for the type of offenses that he'd been convicted of. Go ahead.
I can't disagree that a 50% reduction in an advisory guideline sentence is not a substantial break. I definitely agree with that, but I think that is a different issue than whether or not this terrorism enhancement should have applied. And if it wasn't applied, his guideline range would have been considerably lower even than the 60 months that he got from Judge Tilley. So what I would say is that if you look at the conversations and the times, you know, this begins in February of 2018 with the conversation where, you know, Mr. Cabito does engage in a lot of talk. Then there is some conversation in March, and then radio silence for a pretty good while. And all the conversation, it appears, is initiated, at least it's starting in July, by the agent contacting Mr. Cabito to talk about this silencer and Mr. Cabito's plans. And around that time, Mr. Cabito was saying, you know, I don't think I can do this. I think I think you can interpret that as Mr. Cabito withdrawing in a way, trying to save face. I can't do this. I'm not, you know, I'm older. I've got some ailments. And then ultimately, 2 months later, he withdraws completely. And I think, too, if you look at the timeline, the government waits a month before they even execute a search warrant at Mr. Cabito's house. So clearly, they're not too worried that Mr. Cabito is heading over to the Terry Sanford building to shoot, or else they would have done something about it long before October 25th of 2018. And then when they do search, they don't find a firearm. They find the two silencers, but they don't find anything that Mr. Cabito could attach the silencers to do anything. And so I think that you can consider all of that in deciding whether or not there was sufficient evidence of Mr. Cabito's intent to apply both the terrorism enhancement and the 4 levels of possession of the firearm in conjunction with the felony.
Ms. Costner, can I ask you about the terrorism enhancement and this issue about the Terry Sanford Federal Building and whether or not it is within the special territorial jurisdiction of the United States? So your client did plead guilty, but I don't think he admitted that as part of his plea, right?
That's correct. That was not a part of a possession of the homemade silencer. So,
I mean, you raise this point, and I'm just wondering, how do you suggest that the government should have been able to prove this up? And could the court simply have taken judicial notice of that fact? And can't we do that today?
Well, first of all, if the government, if you look at the record, the government proffers this 18, U.S. Code 1363 as a supporting offense to support the terrorism enhancement. So they put that forward. And it would be my argument that at that point, if they're going to contend that supports it, then they also at least should have some obligation to put on some evidence that the Terry Sanford building fits within that definition of special maritime and territorial jurisdiction, and that wasn't done. Now, whether the court could have taken judicial notice, probably, and whether this court could, probably, but that didn't happen in the lower court. There was no, that issue was not raised, and it was in the court made no findings regarding whether or not that part of that statute applied. I see I'm over my time. Unless there are other questions, I will stop.
All right, thank you, Ms. Cosman. Ms. Wade.
Thank you. May it please the court. The district court properly applied both sentencing enhancements in this case because of the defendant's intent. And that intent was to use his homemade silencers in a planned attack on the Terry Sanford building. And I'd like to start by addressing the terrorism enhancement. And the terrorism enhancement applies when the offense involves or was intended to promote a federal crime of terrorism. And the federal crime of terrorism, that's a defined term. It's set out in a separate statute. There's the two components. There's the specific intent component, and then there's the requirement that there be one of several enumerated statutes involved. But when we're looking at the text of the terrorism enhancement itself, there's two separate prongs here. There's the involved prong, and there's the intended to promote prong. And it appears from my research that this court has only formally addressed the involved prong, but the Second Circuit, the 11th Circuit, and the Sixth Circuit have all addressed this second prong, the intended to promote prong, and explain that that prong is broader than the involved prong, and it applies when the defendant promotes or encourages or has the goal of trying to help bring into being a federal crime of terrorism. And those courts explain that this part of the enhancement can apply even if the defendant wasn't convicted of a federal crime of terrorism, even if he couldn't have been convicted of a federal crime of terrorism. And I think the 11th Circuit in United States versus Manti spells that out. They say there that this part of the enhancement doesn't hinge on the defendant's ability to be able to carry out a federal crime of terrorism, and it doesn't hinge on his degree of separation from a federal crime of terrorism. It hinges on his motive and his intent. And when we look at the record here, we have an undisputed factual record, and the record is full of facts that lead us to show that the defendant's intent was to use these silencers in the planned attack. It was more than just talk. He set up a meeting with this confidential human source. They met on 3 separate occasions where he discussed the plans, and each time he reaffirmed his intent. He said, I still believe in what needs to be done. He was angry at the government. He wanted to retaliate against the government. He said, I think the NSA is spying on everybody and everything. And then he launches into this plan, and he has a detailed plan. He talks about using a common round to help avoid detection. He talks about wiping fingerprints off of the ammunition so that it can't be traced. He talks about putting film over his license plate so when they drive away, their security cameras can't capture the license plate. And then he follows up by sending a picture of the Terry Sanford Federal Building and sending a document describing his grievances against the United States government. And even when he gets to the point where he walks away from working with that particular confidential human source, he still says, I believe in what needs to be done. He still reaffirms his intent to carry out this plan. And then when the search warrant is executed at his residence, they find the homemade silencers, the silencers that he had talked about with the source that could be used to help avoid detection, to help mask the sound of the gunfire, because he wanted to fire into this Terry Sanford Federal Building. So the record is replete with indications that his intent was to promote a federal crime of terrorism. And as was discussed in the position paper and at sentencing, the federal crime of terrorism at issue here is 18 U.S.C. 1363, which makes it a crime to willfully or maliciously destroy or injure property within the jurisdiction of the United States. And to your question, Judge Diaz, about the lack of factual finding about whether the Terry Sanford Federal Building is within the jurisdiction of the United States. 2 points to that. Even if we assume that for some reason that the Terry Sanford Building is not in the jurisdiction of the United States, we still win and this enhancement still applies. And that is because factual impossibility wouldn't negate the defendant's intent. The defendant wanted to carry out an attack on a federal building. That's clear in his conversations with the confidential human source. So even like I said, if the building turns out not to be a federal building, his intent was still to attack a federal building. So that issue is not.
Can't we, this is Judge King, can't we readily take judicial notice that the Terry Sanford Federal Building and Courthouse satisfies that requirement?
Yes, Judge King, that's correct. And I believe we cited that case in our brief that said that you can take judicial notice of that fact. I wanted to offer this alternative argument as well, but
I know, but we could, when I was prosecutor, we used to get the judge to take judicial notice of those kinds of things, and where the district was confines of the like the Eastern District of North Carolina and all of those things matter related to geography, basically.
Yes, that's correct. I agree that this court can take judicial notice of that fact. In this case we cited in our brief, this court took judicial notice of the fact that the Blue Ridge Parkway is within the jurisdiction of the United States. And that same analysis does apply here, that this court could take judicial notice of that fact. It also states in the PSR that the Terry Sanford Federal Building is in the jurisdiction.
I'm sorry, can I ask you about that issue, the Terry Sanford Building? Because, I mean, the case that you cited with respect to the Blue Ridge Parkway is a little bit different. The court would have, our court, a district court, any court, would have to take judicial notice that the federal government accepted jurisdiction over the building, in this case, the courthouse, by filing a notice of acceptance with the governor of the state or in some other manner prescribed by the laws of the state where the land is situated. So how would we know that that actually happened in this case?
Your Honor, there would probably have to be, either we would have to submit something at this stage or there would have to be something submitted at the district court stage. That information is concedingly not in the record. It does say in the PSR that the Terry Sanford Federal Building is within the jurisdiction of the United States, and that fact was not objected to at sentencing when the district court adopted the PSR. And then I would also like to go back to my argument about factual impossibility and how that doesn't negate the defendant's intent. And his intent was to attack a federal building. He was angry with the NSA, he was angry with the FBI, the ATF, and he wanted to retaliate by attacking this federal building. He even said at one point, evil is coming.
So you say it's enough if he thought it was a federal building and intended to attack it.
That's correct, Your Honor. So, for example, if the defendant wanted to,
and he must have admitted that at the guilty plea, that much of it, right?
Your Honor, I don't know if it says in the factual basis that was used at the guilty.
Okay, maybe you don't. All right, I don't know if that's in here either. But anyway.
I'm sorry, I didn't mean to interrupt you.
Does the PSR just state that it's a federal building?
The last page of the PSR, when probation responds to the defendant's initial objections, it does say at that point that the Terry Sanford Federal Building is within the jurisdiction of the United States. And
was that objected to?
It wasn't objected to at the sentencing hearing. Was that your question?
Right, that's my question. It was not, correct?
Correct.
All right.
So this court is under plain error review at this stage. But just to belabor my point on the factual impossibility for another minute, if his plan was to shoot at the president, but he accidentally shot at me thinking that I was the president, that wouldn't negate his intent. His intent was still to shoot at the president. And I think that applies here because he said that his plan was to attack a federal building. So even if the Terry Sanford Federal Building is not a federal building, he still had the intent to try to encourage or bring about this federal crime of terrorism. So for those reasons, this enhancement was properly applied by the district court. And if there's no further questions, I'd like to talk briefly about the firearms enhancement. So when we look at the firearms enhancement under section 2K 2.1 B6B, there's also two separate provisions embedded within that enhancement. When we look at the second provision, it applies if the defendant possessed or transferred a firearm with the knowledge, intent, or reason to believe that it would be used in connection with another felony offense. So the operative words there, the would be, show that this can apply even to felony offenses that have not necessarily occurred. And we filed a letter, 28J letter, on this point, and cited a case from the Ninth Circuit Court of Appeals as persuasive, United States versus Jemison. And in that case, the Ninth Circuit examined this part of the provision and explained this enhancement applies even to felony offenses that haven't occurred. And they gave as an example a bank robbery. If the defendant purchases a firearm and he intends to use that firearm in a bank robbery, even if he hasn't picked out the particular bank that he's going to rob or the particular day that he's going to do it, if he's formed the firm intent to use that gun in a bank robbery, then the enhancement applies. And that's persuasive authority, and that situation applies here. The defendant had the homemade silencers and he planned to use them in this planned attack that is a separate felony. So for that reason, this enhancement also applies. And if this court has no further questions, I would concede my time and rest on the brief and respectfully request that the court affirm the lower court's decision.
Thank you, counsel. Ms. Cosner, you have some time reserved.
Thank you, Your Honors. Just a couple of points. First of all, with respect to the pre-sentence report, whether there was an objection to the pre-sentence report saying that the federal building in Raleigh is in the territorial jurisdiction of the United States, that was a response by the probation officer to defendant's objection. So for the defendant to object to the response to the objections, that's just not something that normally would happen, and it's not in the report itself. So I would just contend that that is part and parcel of the defendant's objections to the pre-sentence report, and that Mr. Kabita's attorney should not have had to also object to the response to the objections. With respect to the argument concerning the increase for possession of the firearm in conjunction with another felony offense, raising the case of Ms. Wade raised the U.S. versus, I think it's Jimenez. Interestingly enough, if you read the case, what happened in that case is the defendant possessed a firearm and said he was going to go on rainbow on some police officer or law enforcement officers. And in looking at the defendant's comments, the court in that case determined that what he did and said was not sufficient to support that fourth-level enhancement. I would argue that Mr. Kabita's comments are more along those lines than evidence of an intent or evidence of this felony offense, and that he that as I said before, his comments were hyperbole, that he actually, other than possessing this this silencer, and he pled which he pled guilty to. The only evidence about anything else that he wanted to do or with respect to that building was what he said to this person on the phone. And in that way, he is more like the defendant in the case cited by Ms. Wade. And I would just ask that the court reverse the decision regarding these sentencing enhancements and send it back for a resentencing. If the court has any other questions, I'm happy to answer them, but if not.
Ms. Cosner, did I understand you to say the distinction is that he was on the phone? You're saying that it would be different if he had been face-to-face with him?
Oh, no, I'm sorry. There were meetings face-to-face. There was text messages. I apologize. I meant more that it was conversation and communication, not evidence of any further actions that he took to somehow further some desire to shoot into the federal building, Gary Sanford building.
All right, thank you. All right, counsel, I know, Ms. Costner, you're a court appointed. I want to thank you, particularly on behalf of the Fourth Circuit. We depend on lawyers like yourself to take these cases and as well as you've done and perform quite ably, and we appreciate that and we thank you so much. Ms. Wade, also, we thank you for your able representation in the United States. With that, we'll have to extend a virtual handshake to you and make do with that the best in terms of our tradition, but please know we appreciate your arguments and thank you so much, and we hope that you'll both be safe and stay well.
Thank you.
Thank you very much.
I'll ask the
Thank you very much.
thank you. I'll ask the deputy clerk to adjourn the court until I guess this afternoon, perhaps.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.